particularly the Chief Justice and Associate Justice of the Court, the lawyers in the staff of the court, as it is our we pray all upon the wisdom of the lead, and our peace, and for the rest of us, and the rest of the ones leaders, guides, and service, in the name of God, and the Son, and the Spirit. Thank you, guys.
Good morning. Almost good morning. As you know, I said yesterday the opinion. I learned about 11 years ago. And some of the things that I know, that are back to the student goes to the about here for 11 years. And just also here for the people here. That's why we at the time draw that we do to extra my issue. That is one of the problems we have in this country, we put it up for the appears a lot of right. So everybody can feel that no church to me about the war. So everything is going up there. Then you see that it's on our extra effort. This thing alone, in the 92s, we have whatever. But neither collaboration on the other. Overnight, don't sleep, make sure that you do not die. You have to bring justice to our people. But we are going in further. We are going to the state. We have to go there, instead of our great eye. We are going to call that, crap on the lead to the case against the everywhere. The awards who have split out against everywhere, but everywhere it's employee, but injury against will not win. 1 year after we are awarded 50,000 each, and in marking, calling, and who were actually not because we go there were several years ago. Well, the Latin we didn't really opinion for you on it. The Latin over there. We did the teaching. So it's quite hard for the opinion and we'll give you an opportunity to have when they put it out there. Thank you.
Yes, sir. The management of Liberia appealed, but the management of Monco that the first appeal and the Prosecutors has bypassed second appeal, appeal without action of damages or wrong is court of judgment.
Mr. Justice Robert and Kennedy, the Speaker of the Court. Good morning. This is an appeal in the Hospital of Damages. This is an appeal going out of an action for damages filed by Julius Sparkle and Monco against the law in the civil law position shall start. The part of this case revealed that Julius Sparkle, CEO of Monco, entered an agreement with Thai Resources China in 2009 for the implementation of 1.5 million metric tons port-length basement Liberia in the amount of US $150 million worth
to what it was filed. Subsequently, U.S. expired, applied, and was granted a loan of $1.5 million by Global Bank and overdraft loan facility of $250,000 for the renovation of multiple warehouses. Following the execution of the loan agreement, Global Bank engaged Liberia into the Capitol agreement, which defined the role of each party as to the storage, sale, distribution, and receipt of the funds. The senior was brought into the company after the necessary paperwork. Appellee began to sell the seed. Nevertheless, Appellee alleged that, contrary to the agreement, appellant rented and sold 6,000 metric tons of the cement that exacerbated the losses of the appellee. The trial compared and made a determination that appellant is liable in damages for the losses of sin by appellee. Meanwhile, there is still an action of death in police commercial court between the same parties. Appellant accepted to the ruling of the prior judge and filed his bill of exception, essentially challenging the prior judge's ruling. In review of the records indicate that when the Capitol agreement was signed, all of the parties had copies of that agreement. Unlike the assertion of the appellee that he did not receive bank statement or the escrow account, the form that the statement was readily available, but instead the appellee opted for restructuring of the loan. We also discovered that appellee wrote a plan requesting to be made to disregard for the use of his warehouse. Therefore, the record has established that the appellee filled the proper sufficient proof to sustain his action of damages against the appellant. It is legally inconceivable that the appellee suffered injury for which damages will attach. Accordingly, the final ruling of the trial court is hereby reversed. This is what
this case was called for hearing because the juniors are almost senior of the central law offices in the tier for the appellant. Councillor Benedict F. Salon of the Salon and Associates Law Offices appear for the PD. Having carefully examined the facts containing the records, listen to the arguments of both sides, and consider the evidence and the law relevant thereto, it is hereby adjudged. It is the law extent in this jurisdiction that damages were attached to indemnify and compensate the injury and detriment suffered by a victim where a wrong has been committed. The record in this case has established that the appellee failed to proffer sufficient proof to establish an action of damages against the appellant. The finding of the lower court in favor of the appellee is without the appeal of the law, and that the evidence having established that the appellant acknowledged, accepted, and signed document after the sale of the cement that he owes the appellee bank the loan balance for which an action was filed against him, he cannot allege damages or wrong. Wherefore, in view of the foregoing, the final ruling of the lower court is hereby reversed. The clerk of this court is ordered to send the merit to the court below, commanding the judge presiding therein to resume jurisdiction of this case and enforce this judgment. Cause I rule against the appellee, it is hereby so ordered. Given on our hand in the seal of the Supreme Court of the Republic of Liberia, this 28th day of August, AD 2026. Signed, Yami Koko Senior Chief Justice, Supreme Court of Liberia. Chief Etaha Wolokoli, Associate Justice, Supreme Court of Liberia. Yusuf E. Kala, Associate Justice, Supreme Court of Liberia. Senior E. Clinton Johnson, Associate Justice, Supreme Court of Liberia. Waka M. Kanyan, Associate Justice, Supreme Court of Liberia.
right?
Yes. John Guy of the city of Kingsville, appellant versus Isaac Mazaboy, appeal an action of the judgment, score for judgment.
Rather than go not accountable to people apart.
The people we shall report in which John while an act was rejected is as a non-actual. At the beginning of the case, John asked for an application, and the applicant must have been considered. Or what time the case around the after the application was done, the instruction of the trial judge. The trial judge gave the instruction that only the people a investigative survey. And so this court disagreed with the trial judge on the team only would serve some powers that the law specifically gave for the board of application. The effect that set all the effects, technical details to be done for the determination of the court. And we said, even though a party considered to go to arbitration, the judge did not have the authority to give a wrong instruction to the board of application. In application, the board has the right to subpoena witnesses to take testimony to that application is the arbitrators that have decided the case. So we said no. Mr. Judge didn't have the right to give this instruction to the board of application. So we are reversing your decision and setting your parties back in the application. Hence, our judgment.
When this case was called for hearing, Councilor Lawrence Wire of the Dominion Law Group and Wellington G. the senior of Fortis Partners LLC, appeared for the appeal. Councilor Samuel Wise of the Topping Law Firm appeared for the appeal. Having carefully examined the facts contained in the records, listening to the arguments of both sides, and consider the laws relevant thereto, it is hereby judged that it is the law that the judge's order are governed by law, and when an order is in contravention of the law, the judgments that proceed therefrom are ordered null and void. And that in the instant case, the trial judge having given an order that governs investigative survey in the case where the parties have submitted themselves to arbitration, and the outcome of the arbitral report be influenced by the judge's instruction, wherein the arbitral board disregarded the relevant facts in the case. Its report is set aside, and a new arbitration order proceeded with in line with Chapter 64 of the Civil Procedure Law revised. Wherefore, in view of the foregoing, the ruling of the trial court denying the motion to vacate the arbitration award is hereby reversed, and the case remanded with the order that the arbitration board proceeds to conduct the arbitration in accordance with Chapter 64 of the Civil Procedure Law of Liberia. The clerk of this court is hereby ordered to send a mandate to the Civil Judicial Circuit, Civil Law Court for Monrovia County, commanding the judge presiding therein to resume jurisdiction and give effect to this judgment. Caused by final determination, it is hereby so ordered. Given on our hands in the seal of the Supreme Court of the Republic of Liberia, this 28th day of August, 2026. Signed, Yami Kwekwe, Senior Chief Justice, Supreme Court of Liberia. Chief Etwaha Wodokoli, Associate Justice, Supreme Court of Liberia. Senior E. Cleveland Johnson, Associate Justice, Supreme Court of Liberia. Michael M. Cannon, Associate Justice, Supreme Court of Liberia. But Mr. Justice Yusuf D. Kalai, having presided over this case in the determination while serving as a second judge, he did not participate in the hearing of determination of this case, hence he did not sign this judgment.
Mr. Walker.
The management of Monrovia Primary School appellant versus Honorable Cyrus Wade and Assay Yankee and others appellees. The plea granted petition for judicial review, score for judgment.
Please, by the court. This matter is a legal dispute between the Monrovia Brewery and three of its employees, namely Mr. Isaac E. Hampton, Mr. Tony C. Hitler, and Mr. James A. Powell. Substantially, the appellee here, the three employees, filed a complaint with the Ministry of Labor, alleging that the management of the Monrovia Brewery Incorporation had dismissed them lawfully. And during the hearing of this matter, the evidence tended to establish that the three employees were involved in a complaint that they filed against on top management of the Monrovia Brewery with respect to insulting languages that they alleged was used by this top management against them. And that culminated into the management asking the top manager to write them a letter of apology. They were subsequently called and presented an instrument purported to be the letter of apology, which they rejected. And because of the rejection, the managing director of the appellant in Monrovia Brewery invited them for a meeting. And the management is alleging that when they invited them for this meeting, they refused to attend this meeting, and because of that refusal, the management proceeded to dismiss them summarily. And they believe that the management did not have the right to dismiss them summarily in the absence of the investigation to ascertain whether or not they were actually invited to this meeting, and so what was the reason for which they did not attend the meeting. The hearing officer, after conducting his investigation, found that indeed the management unfairly dismissed the employee, and then they awarded them some $58,000 United States dollars, right, divided among the three of them. The management appealed took the matter up for judicial review before the Labor Court, the National Labor Court. The National Labor Court heard the matter, agreed with the hearing officer, but reduced the award from $58,000 to $53,000. Again, the management was aggrieved by this action, and then they appealed to this court. In making a determination in this matter, we relied on the handbook of
the Monrovia Brewery, a workers' handbook of the Monrovia Brewery, and a collective bargaining agreement that was consummated between the applicant and the workers. The handbook provides that for actions similar to the one the workers were accused of committing, those workers were supposed to be subjected to an internal investigation. The management was not authoritative to invite them for an investigation to ascertain why they acted the way they acted, if at all they acted that way. But for the management to just proceed and have them dismissed without the conduct of such investigation, that was a violation of that handbook. That was a violation of the collective bargaining agreement. And that was also a violation of the Decent Work Act, Chapter 26. So they violated all of that. So we agree with the hearing officer that indeed the Monrovia Brewery was in error when they dismissed the worker without the benefit of hearing. And we also agree with the neighborhood judge that the award that was given by the hearing officer was excessive, was not being consistent with law, because this school had already made a determination as to how award of that nature is to be determined. And therefore, the award that was the revision of the award that was granted by the National Legal Judge was correct. So the judgment was firm in the case of that notification. That is the essence of our judgment.
When this case was called for hearing, Councillor Abbas has seen appear for the appellate. Councillor Amara M. Sharif appear for the appellee. Having heard the arguments, review the facts and circumstances revealed by the records, and examine the laws controlling the decision by a judge. Chapter 9, Section 9.5, and subsections 9.4a and b of the Decent Work Act 2015 provide that if a party fails to appear at 2 or more consecutive hearings before a hearing office after assignments have been duly served, the hearing officer may proceed to hear the matter without further notice. And that the certified records in the case support the finding in the hearing officers granting the appellee's application for default judgment, which was subsequently perfected when the applicant failed for excuse to attend 5 consecutive hearings after being served with notices of assignment. Hence, the judge of the National Labor Code was within the pale of the law when he affirmed the hearing officer's ruling with modification of the award of United States $58,269.21 to the amount of United States $33,677.25. Wherefore, in view of the foregoing, the ruling of the National Labor Code is hereby affirmed with the above modification. The clerk of this code is hereby ordered to send a mandate to the court below, commanding the judge presiding herein to resume jurisdiction of this case and give effect to this judgment. Cause a rule against the appellant. It is hereby so ordered. Giving under our hands and the seal of the Honorable Supreme Court of the Republic of Liberia, this 28th day of August, 2026. Signed, Yamin Kwekwe Sidion, Chief Justice, Supreme Court of Liberia. Chief Editor Howard Wodokoli, Associate Justice, Supreme Court of Liberia. Yosef B. Kaba, Associate Justice, Supreme Court of Liberia. Senator E. Clinton Johnson, Associate Justice, Supreme Court of Liberia. Edgar N. Cannon, Associate Justice, Supreme Court of Liberia. Moving Patron Appellant versus Honor Joseph M. Connie, Judge of the National Labor Code, and the management of the Liberia Electricity Corporation believes the key period of offense with parties rule for dismissal is called for judgment.
Learning of the day, man. So I was running without what?
Is that we will the decision of future file before the national labor court by the management of MEC. The date of ruling of the very officer of the Ministry of Labor. And that will pay for wrongful dismissal and unfair labor practices or by the appellant moving forward. The appellant was deployed by MEC in July 2017 and goes to the petition of Victory and anti-theft supervisor. On February 22, 2023, a customer, the Navala, complained to LC that the appellant had asked him for $3,000 to secure a dedicated transformer connecting 1,300 as advance payments. And after the transformer was installed, the use of defaulted. The complainant then asked that the employee would place it or refund the money. That the promissory note had been executed by the appellant, asked for the station for 4 to be paid in installment of $400 as an attempt to refund the money. LC called an investigation of this matter according to complaints, and the appellant here, the appeal with lawyer, and then said that this is the technical investigation. We will not lawyer in our investigation. So we went on to the investigation. The thing is, he did not deny, but he said that he couldn't guarantee that there was a corporation with the authority operating the company. And what he wanted, I undertaking the transaction, he couldn't guarantee this, that we do the work. And then he had an investigation found that it was known that he was in fact working with others to attack transformer to the grid, and in fact they were qualified for the work in terms of performance of his work. So they dismissed him. He went to the report, said he was not, they did not call him for an investigation. They tried to catch me and method that before for investigation. And the hearing officer said because of that, they didn't give him an opportunity to face his accuser. His accuser should have been there in face and all that. So he moved with his favor and they wanted him $10,500. LC then took an appeal to the National Labor Court. The National Labor Court heard the argument, and the National Labor Court took the hearing officer ruling. Because he said, at first thing, this is not a matter where it's determined investigation, fact-finding, they needed a lawyer, and of course he said he was not informed of the Maria's rights. He said this is not a criminal case either. So all Maria's rights work, and all this went on. But from all the evidence in the case, he did not, because they wanted to take that and take it to the police station. He had been to a promissory note to refund the money, and he did not deny that he was involved in getting this transformer or part of the when they use that is ended. The hearing officer ruled that there was an internal investigation that which was treated with the LC, and that in fact the LC dismissal was being consonant security. He said work act they had dismissed. So the right thing for and listening to the argument for the fact that that there was an investigation where the president, there were conditions of his performance, and also on that, where an employee needs to know that person the employee who was in order to serve the applicant and hiring prosecutors and everything. So, and we say this is about cases. We can use criminal law and we can decide it's correct. If the president working has something that contrary to his duty and is neglected, it's not really neglect, but it's on and precious duty. And it's wrong. So the other one is seeing this thing about when you charge criminally in this room, when you're working, they can decide what to go to the criminal right or the civil right. At this time, we decided not taking the vote. The state wasn't taking the vote, looking at the facts and taking the gay and the man who charged for its money. But we say that we should take it up. And so that's why we want to be in this case, that's why we see and we look at the fact and we do that we should take the else. We will find a particular job and we want to get another thing with others who work and the time we break up against a full down experience. If you get in this case, everybody is properly. So we're even if you know of the national
When this case was called for hearing, councillors, Lieutenant K. Innes of the Kalamolo and Associates in association of Robbie people of the Jones and Associate Law Consultants Inc. appear for the appellate. Councillor Sagi F. Kamara, in-house legal counsel for the Labrador Electric City Corporation, appear for the appellee. Having reviewed the records and contentions advanced by the councils representing the parties and consider the relevant laws applicable thereto, is hereby adjudged. That's section 14.3 of the Decent Work Act of 2015 stipulates that an employer may immediately terminate an employee's employment for grave misconduct which makes it impossible to continue or to resume the necessary relationship of mutual trust and confidence between the employee and the employer. The proof of the misconduct in a labor battle may be established by admission of the party himself and also by corroborating evidence. And that in this case, where the appellants admitted to the execution of a promissory note at the Painsville police station to refund 1,300 United States dollars, representing the cost obtained from the customer for the procurement and installation of a dedicated transformer, confirms that he acted outside of his job description as a meter and anti-theft supervisor of the appellee. There's a section that he acted merely as a guarantor to have a transformer installed and connected to the LEC bill in contravention of his duty and to the exposure of the corporation to loss of public trust, seen was a breach of the mutual trust and confidence that section 14.3A of the Decent Work Act protects. Wherefore, in view of the foregoing, the ruling of the National Labor Code is hereby affirmed, the appellant's appeal be liked. The clerk of this court is ordered to send a mandate to the court below, commanding the Labor Court judge to resume jurisdiction and give effect to this judgment. Cause of these proceedings are ruled against the appellant. It is hereby ordered. Giving on our hands and the seal of the Supreme Court of the Republic of Liberia, this 28th day of August 2026. Signed, Yamin Kwekwe, Senior Chief Justice, Supreme Court of Liberia. James Edward Howard Olukoli, Associate Justice, Supreme Court of Liberia. Lucy B. Kaba, Associate Justice, Supreme Court of Liberia. Senator D. Clinton Johnson, Associate Justice, Supreme Court of Liberia. Maka N. Cannon, Associate Justice, Supreme Court of Liberia.
Right.
The ECOWAS Bank for Investment and Development, appealing for this United Commodities, believe a big word of actual of debt is called for judgment.
Because the fact that there was an opinion on behalf of the bench.
So, is designated appellate. I say that the appellate for both parties, the journal and the commercial court. The fact is that commodity incorporated approved the requirement to have me to procure the more of $12 million to distribute and sell right to Liberia. As a consequence of this, there was a series of covered women entered into so room. Right into Liberia was into revenue on the Ebola office of Liberia. Consequently, right happened to be paid by the time that the agreement to UCR, now right, ever and our sanction of the agreement, or whoever can decline or accept, and consequently took a bundle of +10.2 of the agreement, into Liberia, and have another 67 paperwork individual right to be to so remaining control of the right of settlement, eventually the right of soul, and observe potential public right and family. At the end of the day, everyone would demand payment for the drop of thing of the money that the lion as a result of that. Usually I plan to pay or went to the table of the farm or security there. The matter of head and sort of becoming that usually I was being responsible for being over $2 million. Ever been attacking and now the fee is the Supreme Court. The Supreme way they be and do. We disagree with some of them who have applied the agreement accident. Or matter of fact, the government, you see how the trend of some information that this is a very only law, very government, because I like it. The people realizing idea is even very and try everyone to put a protocol with fire or why I'm going to see our own. Personally, the couple went to the most of the Nigeria and fired action. Fired series of conferences for the negotiation to agree that money that is being contested $4.5 million plus. It is that no, that not to win the trial. I trial. After the evidence, two of the justices like the commercial court agreed that ever contributed to the law that sustained the business for action. When he elected the people with the rights or well system, and I saw it must be that UCI promotion, clear the law. The two of the judges rule that the amount to be divided 50%. Who ever with UCI pay to us? After examining the record, we agree with the law. However, we contributed rule the law, and I saw one person that we had something for the 4.5 million dollars. By the new way for the real book, and this is our plan.
In this case, was called for your Councilors Emmanuel E. James and Rosemary E. James of the International Group of Legal Advocates and Consultants team. The peer for the appellant, Councilors Kuboyon Wolete, Baju Collins of the Legacy Law Appellants and Lieutenant G. Kras of the Henry Square Association offering the peer for the appellee. Having reviewed the records and the arguments and contentions advanced by the councils representing the parties, and consider the relevant laws applicable thereto to the Sierra Church. That death action based upon agreement, the parties are mandatorily required to live by the dictate, spirit, and intent of the agreement. Now, when party to an agreement elects to exercise an alternative remedy other than the one provided for in the agreement, it takes equitable responsibility for any loss incurred. In the instant case, the appellant having elected to pay for the rights, which is the government of the agreement for a period of 6 months, when the appellee defaulted on the loan payment, the appellant equally contributed to the loss that resulted when some quantity of the rights got damaged in the storage. Hence, it is fair and equitable that the loss sustained in the transaction be equally divided between the parties. That the judgment of the commercial court having disputed the loss between the appellant and the appellee, the said judgment is affirmed. Wherefore, in view of the foregoing, the final ruling of the commercial court is hereby affirmed. The clerk of this court is hereby ordered to send a mail to the court below, commanding the judge presiding therein to resume jurisdiction of this case and give effect to this judgment. Thus, I rule against the appellant and the appellee, and it is hereby so ordered. Giving under our hands the seal of the Supreme Court of the Republic of Liberia, this 28th day of August, 2026. Signed, Lamin Kokwe, Senior Chief Justice, Supreme Court of Liberia. Chief Editor Howard Waterford, Associate Justice, Supreme Court of Liberia. Joseph E. Kaba, Associate Justice, Supreme Court of Liberia. Senator E. Cleveland Johnson, Associate Justice, Supreme Court of Liberia. Baka M. Cannon, Associate Justice, Supreme Court of Liberia.
Right.
John W. Maggie and others, appellant was in the stone hash. Appellee a deed of a motion to justify command of the proceeding to record possession of the property is called for judgment.
This was the Rocket Hamilton, the Ballot of the Court. All the revision code.
Your Honor.
Because the lawyers are high, you guys, I want to have the Capitol the current area Allison. Senior lawyer.
When this case was called for hearing, Councilor Francis Johnson Allison of the Johnson Allison Associates here for the appellants. Councilor Thompson Jaffa, the law officer of Jaffa, appear for the police, having carefully examined the facts contained in the records, listened to the arguments of both sides, and considered the evidence in the law relevant thereto, it is hereby judged that I believe having entered a lease agreement with the administrator cum testamental annexo of the estate for the property in question, and the beneficiaries of said estate having benefited from the lease proceeds, they are stopped from challenging the validity of the said lease, and that summary proceedings to recover possession of real property is a possessory action, not a legal remedy for adjudicating questions of title, probate administration, or other substantive rights. Therefore, the ruling of the lower court is confirmed. Wherefore, you view the foregoing, the final ruling of the civil law court for the 6th Judicial Circuit, Monrovia County, is hereby affirmed. The clerk of this court is ordered to send a mandate to the court below, commanding the judge presiding therein to give effect to this judgment. Cause and rule against the appellants. It is hereby so. Given on our hands in the seal of the Supreme Court of the Republic of Liberia, this 28th day of August, AD 2026. Signed. So sound Justice Howard Woodcock, Associate Justice, Supreme Court of Liberia, Lucy D. Gaba, Associate Justice, Supreme Court of Liberia, Waka N. Kanye, Associate Justice, Supreme Court of Liberia. Lord, Mr. Chief Justice Nami Koko versus Senior, having participated in this case while presiding as a trial judge, he did not participate in the hearing of the determination of this case, hence he did not sign this judgment. Minor Justice Senator Clinton Johnson, being related to one of the parties, recused herself from the hearing of determination of this case, and she did not sign this judgment. Madeleine Dagose, Ms. Sharif, appellant for this Moses P. Yangwe, appellee, the P. whoever the action of the judgment is called for judgment.
Finance Justice Johnson, for the point.
The action of the executive decided her to testify regarding the police report are that was it the squad of action of the executive against the applicant and with the shirt to be identified. In the executive complaint, the applicant alleged that he is the owner of the property, that the applicant is presently occupying. The applicant occupation of the property is a cherry, being the one that was placed on the property by the applicant made comfortable. The record revealed that during a lifetime in which that was the place with the sheriff of the property, taking the property, in according to the fire, build a structure on this land. The applicant alleged that property belongs to the estate of the late Wegman, who was a minister by, which estate was a minister by, with the Samuel Bauer. Vowel is the one that is alleged by being the one who sold the property to the late acquisition. In the trial was established that Mr. Samuel B. Vowel did gave a warranted deed to the late Edward B. acquisition, and that the deed that the applicant presented to this court was an administrative deeds. And so the trial held that they proved their case because in the administration of the late president, Samuel Frank, there was an investigation done, and then it was declared by the Ministry of Justice that Mr. Samuel Vowel would not have authority to sell any property from the estate of Monrovia. And so depending on that, we felt that they said that it had a first, and we said no. If they did not have a first, because that statement, the Justice Ministry or the Executive Branch of Government does not have the authority to determine title in this country. It should have come to the court on the contest title. Further, the interstate estate of Edward B. said the private people also have taken outright possession because of Korea for 20 years. And the law allows for you to claim outright possession at the same time the deed. So the court determined that the application alleged by the applicant that the property of the deed that the applicant is not on was canceled. It did not provide any evidence just that the deed was canceled. And so we had to even dig into the archives of the Supreme Court to find it. And we found that without issue or raised to the Supreme Court, it was sent back to go and determine how whether there was any justification for the canceling of that deed. And so far, I think that was the end of that case, so there was no justification made that the deed was canceled. So we agree with the applicant that she didn't prove her case. She had been there for more than 20 years, and the applicant they said agreed that when they went there, they saw structure there, or their seller had told them that, oh, no, already proved. They are going to cancel that deed. Unfortunately, they did not give them evidence of that cancel. So we agree with the applicant in this case, and so we reverse the decision of the trial court that places voters terminated and in possession of the property, or rather that the person who is justifiably in the position to acquire that property is the person who was there, who had built a house and had lived there for more than 2 years as required by the law, and in the absence of the applicant showing any direct title and showing other evidences, because this evidence is supposed to be so much in a way that is not any defect in it operates in the favor of the other person, even if the title is full, because they have a responsibility, it's a previous responsibility to adequately prove its right to title of the property. And so, to the right to the position of the trial. That's our question.
Well, this case was called for hearing Councillor James Bomo of the Central Law Offices in appeal for the applicants. Councillor James and Kume of Touch Professional Consultants in appeal for the appellee. Having carefully examined the facts contained in the records, listen to the arguments of both sides and consider the laws relevant thereto, this hereby judge. It is the law in and in judgment action that the plaintiff must prevail on the strength of his title and not on the weakness of the defendant's title. That in the instant case, the appellee having failed to establish the superiority of his title by preponderance of the evidence, the appellant cannot be ejected and ousted from the subject property. And that it is also the law that adverse possession will lie where the appellant enters the property notoriously, openly, and remain in possession with uninterrupted objection to sell occupancy for more than 20 years. Hence, appellant's possession is justified by law. Wherefore, in view of the foregoing, the final ruling of the trial court is hereby reversed. The clerk of this court is ordered to send a minute to the Sixth Judicial Circuit to law court for Roosevelt County, commanding the judge presiding therein to his own jurisdiction over this case and give effect to this judgment. Because I rule against the appellee, it is hereby so ordered. Giving honor our hands and the seal of the Supreme Court of the Republic of Liberia, this 28th day of August 2026. Signed, Yami Kwekwe, Senior Chief Justice, Supreme Court of Liberia. Chief Edward Howard Wodokoli, Associate Justice, Supreme Court of Liberia. Joseph D. Kabat, Associate Justice, Supreme Court of Liberia. Sienna D. Clinton Johnson, Associate Justice, Supreme Court of Liberia. Walker and Cannon, Associate Justice, Supreme Court of Liberia. Rosalind, Besse, and all those acting, operating under her control, appellants versus Austin, the Clark Senior, appellee, the P, word of an action of rejectment is called for judgment.
That's right, Justice. I second what this action was instituted in the law of Mr. Austin the Clark Senior, seated memorable against Madam Rosemary Bassey, to have Madam Bassey evicted, boosted from the property and the supply claim to be his. It is important that you have an appreciation of the facts in this matter. Mr. Clark was initially married to Madam Rosaline Bassey. Two lived together actually. Subsequently, Mr. Clark and Madam Bassey divorced, and Madam Bassey went away. Thereafter, for reason not consequential here, Mr. Clark allowed Madam Bassey to move in with him in his house and live together in that house until, for some reason, Mr. Clark decided that Madam Bassey stay in the property was no longer necessarily notify her to leave. And then she told him, well, they didn't call one to me, I need some money to go. So Mr. Clark agreed to give her $2,000. When they offered her the $2,000, the next thing she gave us to say, in fact, this property is for the both of us, it's jointly owned by the both of us. You recall that one day you transfer title of this property to a common friend of ours, and that common friend of ours, in return, placed the title of the property in the name of the both of us. So we jointly own this property, and therefore you have no right to ask me out of this place. Agreed by this, Mr. Clark instituted this action against those named that the lower court heard the case, and the lower court found that Madam Bassey story was not supported by the evidence that was produced, and they moved for Mr. Clark. Madam Bassey appealed to the Supreme Court. We went through the evidence, especially the testimony of the lady that is said to have transferred the that the lady who the supply said to have transferred the property and who subsequently transferred the property in the name of the supply and Madam Bassett. That lady came and testified and said, no, I never, the supply never transferred no title to me, and I never transferred no title to both of them. So that statement is not true. So based on that, all of these of evidence that were used in the trial, we find no justification to disturb the finding of the lower court to remove that property return over to Mr. Clark, who he was there. But then, you know, another issue brought out that we thought that we should address, and that had to do with the children, because Madam Bassey and the children were living in the house. Whether should we evict all of them, or should we evict only Mr. Bassey and the children when Mr. Clark's children? So we decided no, the action was decided not against the children. The children got the right to stay in the father's property. It's really against Miss Madam Bassey, who was not married to the man and who had no reason to be in the man house if the man didn't know from there. But that was the essence of our child.
Well, this case was called for hearing because Judge Willie after side law office is appeared for the appellants. However, M. Wiggins read at the readiness from the appeal for the appellee. Having heard arguments, reviewed the facts and circumstances revealed by the records and examined the laws from truly initiated by the judge. That the Civil Procedure Law Revised Code Chapter 1, Section 62.1 provides that any person who is rightfully entitled to the possession of real property may bring an action of judgment against any person who wrongfully withholds possession thereof. Such an action may be brought when the title to the real property as well as the right to possession thereof is disputed, and that in this case the appellee having presented clear and convincing evidence of his fee simple title to the disputed property, thereby refuting the co-appellant's claim of joint ownership and any alleged right of survivorship, the trial judge's final ruling in favor of the appellee ought not to be discharged. Wherefore, in view of the foregoing, the final ruling of the Sixth Judicial Circuit Court for Monrovia County is hereby affirmed. The clerk of this court is hereby ordered to issue a minute to the court below, commanding the judge presiding therein to resume jurisdiction of this case and give effect to this judgment, caused by rule against the co-appellant, and it is hereby so ordered. Giving honor our heads and the seal of the Honorable Supreme Court of the Republic of Liberia, this 28th day of August 80, 2026. Signed, Yami Kwekwe, Senior Chief Justice, Supreme Court of Liberia. Chief Senator Howard Wodokoli, Associate Justice, Supreme Court of Liberia. Joseph D. Gaba, Associate Justice, Supreme Court of Liberia. CNN D. Clayton Johnson, Associate Justice, Supreme Court of Liberia. Maka M. Cannon, Associate Justice, Supreme Court of Liberia.
All right.
Chair Liberian Enterprise, appealing for this SSF Enterprise to be the P grant of an action of debt is called for judgment.
The Chief Justice will give an opinion on behalf of the court.
I thought that. But I feel like you have not correct at that time. And I thought of the agreement, rehabilitation, to gravel road, with no parking. The argument contends that the completed work and that the argument for issue 101 $100,000 that's enough. We refuse the paper we buy, and then I go in the echo of another country. The argument contains that no, that will be there. and that in fact the agreement was cancelled by mutual consent. But the evidence before us indicates or clearly shows that the trial was completed because the engineer from Minister of Culture, he had testified as part of kind of completed the trial. There was nothing that was said 500 issues that was so in the court below, however, we transfer with that speed the law. The detective law in favor of SSF and China to be the sport. But we are local short China completed the negotiation with everything I could be referring to. And I don't know such major cancellation agreement. But the major cancellation agreement be the two-party agreement. For instance, the rule letter that wrote to some Liberians that we are the ones to inform you that we are elected to cancel the agreement. If you like to cancel the agreement, so cancel it, you can now refer to the major or single major agreement. So we are against that in people sound like they are on a leg or holy work and the program of the law and I will put the order is about
Judgment.
This case was called for hearing Councilors G. Moses Speaker, Justice, advocates and partners in association with Mark and Emmanuel, the Your Lordship on Secretary for the applicant. Councilor J. Jonumowa of J. Jonumowa Associates, because Chambers here for the applicant. Having reviewed the records heard the arguments and contentions advanced by the councils representing the parties and consider the relevant laws applicable thereto in this hereby adjudged. That there is no disputing evidence that the applicant entered an agreement to do two gravel road works in Lofa County, Republic of Liberia, with no clause stating the ground for termination of the agreement. It is the principle of contract law that a contract may be terminated by order of court or by mutual consent. In the instant case, the evidence having established that the PD unilaterally terminated the contract without order of court consent with applicant, the trial court was in error when it upheld the cancellation. Hence, the PD is indebted to the applicant in the amount of 101,372 United States dollars as an outstanding payment left on the subcontract that was executed between the parties. When the final ruling of the lower court is reversed, I believe it is adjudged liable to the applicant as stated above. The clerk of this court is ordered to send a mandate to the court below, commanding the judge presiding herein to resume jurisdiction and give effect to this judgment. Cause and rule against the appellees in the hereby so. Given on our hands in the seal of the Supreme Court of the Republic of Liberia, this 28th day of August, 2026. Signed, Yami Kwekwe as the Senior Chief Justice, Supreme Court of Liberia. Chief Secretary Howard Wolokami, Associate Justice, Supreme Court of Liberia. Yosef B. Kaba, Associate Justice, Supreme Court of Liberia. CNN E. Glendon Johnson, Associate Justice, Supreme Court of Liberia. Maka and Cannon, Associate Justice, Supreme Court of Liberia.
Number 10.
The Republic of Liberia to the Ministry of Justice in the management of more than mean conditional applicants versus Monrovia of the City of Monrovia. I believe the people action of rejectment is covered.
The Department and Manager will be by 12.
Masukumba Montgomery, I believe, was file an action of rejectment at the state website for the robbery, the reporting of their property by more than me. I had claimed that stated that the criminal of the property by virtue of the court of the issue to hold by the monthly people for Monrovia County. In response to the complaint, appellant filed a 13-count answer containing that it is a tenant of the government of Liberia, evident by the memorandum of understanding executed with the government, that the government has appropriated the disputed property for the construction of the Ministry of Justice more than 50 years ago. The appellee is taking advantage of the war because no public offices were vandalized and documents being placed. Assuming the property is legitimated, belongs to the appellee, the law prohibits the invasion of the government of real property, which is used for public purpose. On February 23, 2011, the appellee filed an 11-count reply to the appellant's answer, essentially confirming the affirmation in the complaint that the government never paid them anything to expropriate the property. On October 26, 2017, the government made an application to intervene along with its intervenants answer. Being a grantor of the said property to more than me, an intervention was required to defend appellant that was running the school for the school project to the country. At the jury trial, each of the parties produced 4 witnesses in support of their respective claims. Following the deliberation by the jury, in verdict for the return in favor of appellee, appellant with the exception to the verdict, filed a motion for new trial, which was denied. Accordingly, appellant perfected his appeal to the Honorable Supreme Court. After reviewing the trial records in the bill of exceptions, the court has held that its long-standing principle in rejecting facts that the plaintiff was put his case on the strength of his life and not on the weakness of the defendant's side. In support of this claim, appellant produced 4 witnesses to include Mr. Tosiko Borges, Commissioner for Land Policy, Land Authority, Mr. Moses Gay, Director of Real Estate General Services Agency, Dr. Kubana Ikoke, and Mr. Richard David. They all testified that the property was government and occupied for several years. Appellee for all to reach the 4 LA suburb, Director of ADR, Land Authority. He testified that based on the complaint of the appellant, the research was conducted at the Ministry of Foreign Affairs and the General Services Agency. He concluded that even though the subject property was listed as a cheapwater property, there was no document establishing government's ownership of this property. This testimony was never proven. Considering the records in the testimony of the witnesses, it is the considered opinion of this court that the appeal should be denied. The final ruling of the trial judge and the verdict of the jury is hereby affirmed. Appeal is denied.
This case was called for hearing councillors Augustin C. Fire, Solicitor General of the Republic of Liberia, J. Adolfo Kanon III, and J. D.K. Kalawa of the Ministry of Justice appear for the applicants. Councillor Ali Cooper and Philip Y. Congo of the Congo and Associate Law Firm appear for the plea. Having carefully examined the facts contained in the records, listening to the arguments of both sides, so that the evidence and the law relevant therefore to be seen by a judge. It is the law that the plaintiff in an injunction action must recover on the strength of his or her title and not on the weakness of the defendant's title, and that the investigating court or government agency having established that the disputed property is not owned by the government, seen is deemed as an admission. The jury verdict, as confirmed by the court's finding, therefore needs not to be distressed. Wherefore, in view of the foregoing, the appellant's appeal is denied. The final ruling of the State Judicial Second Civil Law Court Monrovia County confirming the verdict of the jury is affirmed. The appellants are ordered ejected, boosted, and evicted from the subject property, and the appellee placed in possession thereof. The clerk of this court is ordered to send a mailing to the trial court commanding the judge presiding therein to resume jurisdiction of this case and give effect as justice. Cause are disallowed. It is hereby so ordered. Given on our hands in the seal of the Supreme Court of the Republic of Liberia, this 28th day of August 2026. Signed, Chief Editor Howard Watercolly, Associate Justice, Supreme Court of Liberia. Lucy B. Kaba, Associate Justice, Supreme Court of Liberia. Helen E. Clinton Johnson, Associate Justice, Supreme Court of Liberia. Walker N. Kane, Associate Justice, Supreme Court of Liberia. Lord, Mr. Chief Justice Yami Koko Vice Senior, having participated in this case while serving as a trial judge, he did not participate in the hearing or determination of this case. Hence, he did not sign his judgments. I believe in the record. Mr. Aaron Robinson, appellant for this mission. Marlin grants Oyu, the people, summary proceeding to record possession where property is called for judgment.
Father, the playground property of our court.
Council and action was clear to be called possession of property. The evidence serves from a certified political show that it applied in the Monrovia court almost rather all the way back in 2007, where the Afro Republican challenged faculty and chief of counsel of the accolade, which is very advanced for a $5,000 land to residential building their own with as comparatively Monrovia like Liberia. I won't die. The fact that cannot be pursued, he is dead. The evidence will show that on the issue of fraud of race in the court, the public court ordered the matter of the civil law for determination of the court. And subsequently thereafter, after the trial and summary proceeding in the civil law court, the applicant filed an answer and filed a bill of information also on the issue of fraud. A careful perusal of the records show that immediately prior, on the day which the summary was called for hearing in the civil law court, the judge entered a default against the applicant. And when the perusal of the record, we'll see how first, the information that was filed ever determined. Secondly, what was in the evidence that the applicant made the perfect judgment. Perfect is an principle of knowing our jurisdiction, that when perfect judgment is ordered against you, you should make it perfect. The record before the trial judge show that two issues were raised in which the judge had on. One was the substitution of practice, and then both parties did not give up any information as to when Aaron died. The court did not do that. But the court dealt with the two issues that identified that the imperfect judgment was not imperfect, and the issue of fraud was not considered by the court. So, hence, see that there were errors done and we wish to go back and correct it.
When this case was called for hearing, Councillor Simala B. James, Rosemary B. James of the International Group of Legal Advocates and Consultants Inc. appeared for the appellate. Councillor Anthony B. Mason of Henry Strand, an associate law firm, appeared for the appellee. Having carefully examined the facts contained in the records, listened to the arguments on both sides, and considered the law relevant thereto, it is here that it is the law that a default judgment is an imperfect judgment that must be made perfect by the production of sufficient evidence by the plaintiff in the substantiation of his claim. That in an instant case, the trial judge, having rendered a default judgment without informal production of evidence to make the default judgment perfect, the said judgment will be set aside. In an instant case, the trial judge, having ignored the bit of information which raised the issue of fraud, and proceeded to make a determination in the summary proceeding by default judgment, such ruling is contrary to law. Wherefore, it be foregoing the ruling of the trial court granting default judgment in favor of the appellee is hereby reversed. In the case remanded for trial de novo, the clerk of this court is hereby ordered to send amended to the 6th Judicial Circuit Civil Law Court for Monrovia County, commanding the judge presiding therein to resume jurisdiction and give effect of this judgment. Cause of that final determination, and it is hereby so ordered. Given on our hands in the seal of the Supreme Court of the Republic of Liberia, this 28th day of August 2026, signed Chief Senator Howard Wodokoli, Associate Justice, Supreme Court of Liberia. Yusuf D. Kabal, Associate Justice, Supreme Court of Liberia. Senator D. Clinton Johnson, Associate Justice, Supreme Court of Liberia. Walker N. Cannon, Associate Justice, Supreme Court of Liberia. Note, Chief Justice Nyami Koko Baise Senior, having presided in the determination in this case while presiding in chambers, did not participate in the hearing and determination of this case, hence he did not sign this judgment. Charles Brown of the USA appellant and his honorable reporter done by his son judge, to Second Court, March 10, 2025, first appellee, and Madam Ellen F. Brown, Peter Brown, second appellee, appeal regarding the petition for the writ of certiorari and scope of judgment.
The third person, you serve Kara, Alani, Lati, for God. I think I want to ask justice. Nobody is still concerning cases like this. I'm only the third that's very oil who was subjected to a test with the Supreme Court. This is the problem of the Supreme Court because the issue is very, very elementary. Yes, present the issue to give our judgment. The issue is whether or not a ruling by the Supreme Court in favor of party is upon which ruling another party is possessed of party of a property. If that ruling is appealed to the appellate court and appellate court reverse that ruling, should the appellant not be repossessed of the property? That's a simple issue. The magistrate rule dispossess somebody of a property, somebody proceeding with no possession of their property. The matter came up to the circuit court on summary proceedings. The circuit court heard the summary proceeding, reversed the ruling, and then they go to go back. Then the person, the other party, the party against whom the ruling was entered, have been returned to the property. Now the second judge refused to return the person to the property, and the other party did not even appeal. Refused to return the party to the property. They took the matter to the Chief Justice. The Chief Justice said, no, you all value return that person to the property and let that person, they don't have your case in the way it's supposed to be held. So this was a default judgment. Then somebody appealed for another come to the Supreme Court, or the Supreme Court is still what? That's the major cause of question here. What is the Supreme Court to say that the judgment that has been reversed? It should then remain that way. The person will not be returned to silver score. So we granted the appeal, tell the Chief of Justice ruling ordering that the party be returned to silver score ante. They don't feel like they proceed with the matter according. That's the essence of our question. In such a case, we need to send it to the party, the opinion, you know, what consider quality. But I think that's someone who will consider quality.
For this case was called for hearing Councillor Simon Sereno Sifos appear for the appellees, Councillor Jean and Kumi appear for the appellant. Having heard arguments, reviewed the facts and circumstances revealed by the records, and examined the laws controlling it is hereby judged. It is a well-established principle of our jurisprudence that when a ruling has been enforced and subsequently reversed by the appealing court, the parties ought to be returned to status quo ante. And that in this case, the appellate court having reversed the ruling of the magistrate court but failed to return the party to status quo ante, the Chamber's justice was within a day of the law when she ordered the parties to return to status quo ante. Wherefore, in view of the foregoing, the alternative rate issue is upheld and the preemptory rate order is sustained. The clerk of this court is hereby ordered to send a memo to the court below, commanding the judge presiding therein to resume jurisdiction in order the appellee repossess consistent with his judgment. Cause are disallowed. It is hereby so ordered. Giving on our heads and the seal of the Honorable Supreme Court of the Republic of Liberia, this 28th day of August 2026. Signed, Yami Kokobaise, Senior Chief Justice, Supreme Court of Liberia. Chief Senator Howard Waterfall, Associate Justice, Supreme Court of Liberia. Yosef B. Kaba, Associate Justice, Supreme Court of Liberia. Paka N. Cannon, Associate Justice, Supreme Court of Liberia. North, Madam Justice Yenan D. Clinton Johnson, having recused herself from the hearing of this case as the appeal emanated from her ruling made while presiding as Justice in Chambers, she did not serve this judgment. The management of the General Auditing Commission, GSC, Napidan versus Honor Cyrus, we, the Officer Division, Labor Standard, First Appellee, and Amos Goba, Second Appellee, and P. Petition for Judicial Review, is called for judgment.
The Chief Justice will deliver the opinion on behalf of the bench.
For matter of the General Auditing Commission is missed or redundant. The General employees also legally redundant the file a complaint to Minister of Labor. Go ahead, complaint, rule, in the applicant, fees, or subsequently prepared to this court. Look at the record, that is matter of jurisdictional ground. It's the simple jurisdictional ground, both our lawyer and our judges need to understand. The law is that any government agency or autonomous agency of government that in operation for regular national budget purpose is not subject to Ministry of Labor. Unlike other government agencies that there is a two form of there's a labor dispute is subject to Ministry of Labor. In this recently, General Auditing Commission total budget provided by the national budgetary process. It doesn't generate any form of. So any law that people went through would have known the difference and say you are paid fair to civil credit and not to Ministry of Labor. Online social security for this center, we generate no form of good lawyer if you were to go to this simple elementary and lawyer then they can put this frustrating. So this is the only principle for which we try to give. Ministry of Labor can go to the decision over period in period.
When this case was called for hearing, Councilor Rodney P. Poor, in-house legal counsel of the General Auditing Commission, GAC appeared for the applicant, Councilor Arthur T. Johnson of the Consortium of Legal Practitioners Inc. appeared for the appellee. Having reviewed the records, heard arguments and contentions advanced by the councils representing the parties and considered the relevant laws applicable thereto in this hereby judge. That it is the law stated that it is jurisdiction that any ruling or judgment of a court or tribunal without jurisdiction is void ab initio. The law extending this jurisdiction is that a labor dispute involving a public autonomous agency and its employees, in which agency is funded via national budgetary allocation, such dispute lies exclusively within the jurisdiction of the civil service agency. Hence, the Ministry of Labor was without jurisdiction to hear or in this case. Wherefore, you will before going the final ruling of the National Labor Code, affirming with modification of the ruling of the Ministry of Labor hearing officer is hereby reversed. The clerk of this court is ordered to send amended to the National Labor Code, commanding the judge presiding to resume jurisdiction if effect of this judgment, cause and rule against the appellees. It is hereby so ordered. Giving honor our hand in the seal of the Supreme Court of the Republic of Liberia, this 28th day of August 2026. Signed, Yami Kwekwe, Senior Chief Justice, Supreme Court of Liberia. Chief Associate Justice, Supreme Court of Liberia. Yusuf D. Kaba, Associate Justice, Supreme Court of Liberia. Senior D. Clement Johnson, Associate Justice, Supreme Court of Liberia. Waka and Kane, Associate Justice, Supreme Court of Liberia.
I didn't have people live up. But I didn't know that's been good. that right?
Yeah, no.
Please call the number involved to go there. Come on, number.
Case number 23. The Liberia Bank for Development Investment Liberia urges President appealing for his that a proper now to protect be action on damages for wrong is called for judgment.
There's the actual of damages for wrong. A careful review of the file will show that after all the monthly salary between borrowed $10,000 from the applicant. The all March 26 paid in full amount. And after the payment of the full amount, it's time to go back and forth to the bank to get his feedback. So the use is the corporate fee that he had to private feedback from that. He went up and down behind the bank to get his feedback. The bank did not give him back the fee. So after 8 months, he worked. And the bank did not give him the feedback. So he filed an action for damages for wrong. Even that, in the time that was going up and down the bank the fee, and he had a couple of proposals that he could use that fee for to get other money to continue his work. Because he normally uses the fee to borrow money and use it as a collateral. So during trials, the bank came back, they did contact the applicant to come and pick up the fee. And the question the trial was how they would contact the applicant. They said, we tell the court. So the subpoena in records. And the records show that, yeah, people don't trace the record. They didn't think that the staff called me and complained that this was a written contract between people. Number 2 is also that he had written the people writing back. In another receipt of the letter, he did not write back. They say, yeah, oh, have called me, you come. So based on that, the fact that the fire level they awarded him $200,000. So on the case before that, the applicant agreed that he suffered injury. But the injury, the damages awarded have to be commensurated with the injury that he suffered. So we will not give him the $200,000. So we decided to do that. It was recognized on the side of the bank, he will hold his deed. He went seeking for it and they did not give it to him. After they themselves have admitted and paid in full. Hence, I was judging. It was illegal. And then they found
When this case was called for hearing, Ibrahim B.C. last senior of the Heritage Partners and Associates appeared for the appellate councillors Bomolo G. Kanaka, Chair 1C, Conclave Associates Law Offices appeared for the appellee. Having carefully examined the facts contained in the records, listened to the arguments of both sides, consider the laws relevant thereto, and this that judge. That it is the law that damages is defined, damage is defined loss, injury, or deterioration caused by negligence, design, or accident. And the 3 essential elements considered to be the basis for any thought action are A, evidence of legal duty, B, breach of the legal duty, C, constitute cause of that breach. And that in an instant case, the appellant having wrongfully withheld the appellee's deal with no justifiable reasons, damages will lie. Wherefore, in view before going the final ruling of the trial court awarding the appellee damages of United States $200,000 is hereby modified. The appellant is ordered to pay to the appellee general damages in the amount of $35,000 United States dollars and punitive damages in the amount of $15,000 United States dollars for the appellant's wanton and reckless act in failing to pay the appellee's deed. The clerk of this court is ordered to send a minute to the trial court commanding the judge presiding therein to resume jurisdiction of this case and give the defense of this judgment. Cause and rule against the appellant in this year last month. Hearing on our hands and seal of the Supreme Court of the Republic of Liberia, this 28th day of August 2026. Signed, Yami Kwekwe, Senior Chief Justice, Supreme Court of Liberia. Chief Edda, Wodopami, Associate Justice, Supreme Court of Liberia. Yusuf B. Abba, Associate Justice, Supreme Court of Liberia. Senator B. Freeman Johnson, Associate Justice, Supreme Court of Liberia. Mother M. Cannon, Associate Justice, Supreme Court of Liberia. The management of Notre Dame Investment Limited petitioner versus Honorable President, the mobile officer, Ministry of Lands and Energy, the Ministry of Lands and Energy's respondents appeal the petition for re-argument is called for judgment.
Mr. Justice Barker, and kind of speak by the court.
This matter is before this court on re-argument following an appeal that was decided on February 13, 2026. Petitioner not being satisfied with the February 13, 2026 opinion has asked this court to revisit his said opinion for what it termed as being a permanent error, principally asserting that it paid taxes to the Federal Revenue Authority (LRA) for its mining licenses, but this could determine otherwise, thus affirming the cancellation of petitioner licenses. That even if petitioner has reported in its tax obligation, section 9.14C of the Mineral and Mining Law of 2000 requires that petitioner be given default notice and allow time for appeal. That a court wrongly interpreted mining activity as defined under section 1.3 BB of the Act adopting the new Mineral and Mining Law of 2000. That this proof upon review of the records indicate the petition for re-argument and the argument of parties. We are of the opinion that no particular issues were overlooked as raised by the petitioner. The contentions as raised by the petitioners in the petition, especially referencing section 9.1C of the Mineral and Mining Law of 2000 and section 1.3 BB of the Act adopting the new Mineral and Mining Law of 2000 were all addressed in February 2026 opinion. Accordingly, this court sees no reason why it disturbs its opinion of February 2026. Therefore, the petition for re-argument is hereby conceived to be denied without opposition.
This case was called for hearing Councilors J. Johnny Momo and M. Wakings Wright appear for the petitioner. Councilor Augustine C. Fire Solicitor General of Liberia, Isaac B. Williams and Eugene Massey appear for the respondent. Having carefully examined the facts contained in the records, listen to the arguments of both sides, and consider the evidence in the laws relevant thereto, it is hereby adjudged. That Rule 9, Part 1 of the revised rules of the Supreme Court provides that re-argument will be granted only where some palpable, substantial mistake has been made by inadvertently overlooking some fact or point of law. And that the February 13, 2026 opinion of this court having addressed all the relevant issues, and that the petition for re-argument having failed to raise any factual or legal issue not considered in the opinion, the petition for re-argument is hereby denied. Wherefore, if you before going, the petition for re-argument is hereby denied and dismissed. The clerk of this court is hereby ordered to send a manual to the court below, commanding the judge presiding here to resume jurisdiction of this case against the effect of this court's judgment of February 13, 2026, and it is hereby so ordered. Given on our hands in the seal of the Supreme Court of the Republic of Liberia, this 28th day of August 2026, signed, Yomi Koko versus Senior Chief Justice Supreme Court of Liberia. Chief Senator Howard Woodward, Associate Justice Supreme Court of Liberia. Josie D. Kabash, Associate Justice Supreme Court of Liberia. Senator D. Cleveland Johnson, Associate Justice Supreme Court of Liberia. Waka N. Cannon, Associate Justice Supreme Court of Liberia.
Well, the pink
Sasiwa and the testing estate of Joseph Trinity, applicant versus Philip Conrad Cox and others, appeals appeal, where the petition for the beneficiary is called for judgment.
whether the and the in our government with people at what?
This matter is before us, all appeals on the weight of statutory critical with too much justice. Too much justice is tell that. One that acts of being a master between the landlord and the tenant. That much possibly pleasure of the debt of factory and different establishing pleasure to the debt policy. Let the winner and the music party are landlord. Where the winners, sour, and industry active or children and pleasure of the policy of the invested or common tax, they are divided the substitute their appropriate action to call their policy. They are from the evidence in the record, they have found interfering with proposal to intervene in the actual delivery proceeding to recall the show real policy brought by the petitioner. It is therefore opinion that the intervention of SARS and industry justice of the community be denied and continue of the proceeding before the session of real policy between the petitioners be considerable by the title. The title should not involve that allow this guidance and community to contain the spirit of the law and thereby demonstrating justice to the administration of justice. That was consumer justice. And we said that in affirming consumer justice opinion, we said that under the law and principles are stated therein, and the action planning failed to provide proof of evidence existing the relationship between the applicants and the applicant individual. It is the opinion of this court that the presentation of activities by the applicant and proof of their claim of right to pleasure of the property subject of the litigation which they claim as the ground of the being in an analysis of appeal. As usual, we the intended purpose of the actual proceeding to recall possession of their property, in which title examining issue, rather than possession of the issue. Therefore, it is our soul that the doing of the chamber justice, granting the right of supermarket to the lawyers, the doing of the judgment before the law be affirmed and seen with them affirmed. Hence our judgment.
When this case was called for hearing, Councillor Jimmy Sabomo of the Central Law Office is appeared for appellants. Councillor Denise S. Fukan of the Jones & Jones Law Firm appeared for the appellee. Having carefully examined the facts contained in the records, listened to the arguments of both sides, and considered the laws relevant thereto, it is hereby adjudged. It is the law that tenants cannot contest the claim of title of their landlords or a shared ownership in another person. For a motion to intervene to lie in a property matter, the intervener must show that he has a vested interest in the said property, usually adversely affected by the court's judgment, and in the instant case, the applicant having failed to provide proof of his interest in the disputed property, and that the evidence show that no landlord and tenant relationship existed between the applicant and the tenant, the motion to intervene was properly denied. Wherefore, in view of the foregoing, the alternative rate issues upheld, and the preemptory rate ordered is sustained. The clerk of this court is hereby ordered to send a mandate to the Sixth Judicial Circuit Civil Law Court for Monrovia County, commanding the judge presiding therein to be told variation in the of this judgment, because I rule against the appellants in this hereby so on. Given on our hands in the seal of the Supreme Court of the Republic of Liberia, this 28th day of August, 2026. Signed, Nami Koko versus Senior Chief Justice, Supreme Court of Liberia. Yusuf B. Kaba, Associate Justice, Supreme Court of Liberia. Senator D. Clinton Johnson, Associate Justice, Supreme Court of Liberia. Waka M. Cullen, Associate Justice, Supreme Court of Liberia. Lord, the appeal only emanated from the ruling of Madam Justice James Etta Howard Wodokoli, while residing in Chimas, she did not participate in the hearing of determination of this case, hence she did not serve this judgment. 16. Wellington B. Casa alias Bishop Appellant versus the Republic of Liberia by the Ministry of Justice and the appeal for the crime of murder is called for judgment.
On May 15, 2022, at approximately 7:38 a.m. in the LPRC community in Gardnerville, Monrovia County. The white-blessed banner of Madam Fatou Yasuwa was found lying in a pool of blood. There is absolutely no doubt that Madam Yasuwa was murdered. But the issue that was brought before the court was to determine whether Mr. Wellington B. Kaiser or boyfriend was the one who murdered. When the body was discovered, the police commenced their investigation and arrested as culpable Mr. Kaiser. An indictment was brought against Mr. Kaiser, and the trial had, which culminated in the guilty verdict against Mr. Kaiser. And Mr. Kaiser appealed from this. This guilty verdict was affirmed by the trial judge. This affirmance was appealed by Mr. Kaiser before this court. So it became our duty to search the record and determining whether or not the state proved beyond a reasonable doubt the guilt of Mr. Kaiser. There is a maximum of law that it would rather be better to let go 10 guilty persons than to convict one innocent person. We said the evidence of the state. The state did not rely upon basic fundamental evidence. That was a CCTV footage of the crime scene. When this footage was produced, not by an expert, the applicant challenged this footage, claiming that the footage was blurred, the images were not very clear, and that the person that was in the footage was not him. It was different from him. The person was short, he's tall than that person, and the rest of it. But the state did not produce any expert come and speak to this video footage, which was one of the cardinal evidence available to the state. The second piece of evidence that was produced by the state that was of importance to us is the alleged knife that was said to have been used to take the life of who Yasu. Again, the forensic examination of this knife is said to have had one print of a finger on it. What made that knife more questionable is that the expert that performed the forensic investigation on that knife was not produced when another police officer was removed to come and testify to that knife. While that police officer testified that the knife had the fingerprint of the applicant on it, the report of the forensic expert shows that there was only one fingerprint on the knife, and that print resembles that of the applicant. The third difficulty we have with this case is that the indictment provides that the deceased, the former Chief Justice used a lot of mention, I don't know how to pronounce the word deceased. I think deceased, I don't know about disease or the deceased. But the deceased, the indictment said that the deceased was murdered around 7:30 in the evening. Whereas the examination of the body, the medical examination of the body shows that the murder took place sometime 2:30 a.m. in the morning. That also was a variance. So considering all of those variances, we were not inclined to give credence to the finding of the lower court, and therefore we order the lower court ruling reversed. I
It's the essence of when this case was called for your concerns, T. Joseph B. Devlin, and Jala G. Zumo, William O. Johnson appeared for the applicant. Councilors and Austin C. Fire, Solicitor General of Liberia, William Powell, Howard G. D. of the Ministry of Justice appeared for the applicant. Having heard the arguments review the facts and circumstances revealed by the records and examine the laws controlling the hereby judge. That section 2.1 of the criminal procedure law provides that the court. A defendant in a criminal action is presumed to be innocent until the contrary is proved. And in the case of a reasonable doubt where his guilt is satisfactorily shown, he is entitled to an acquittal, unquote. This presumption of innocence remains with the accused throughout the proceedings, and the state bears a continuing burden of establishing guilt beyond reasonable doubt before a conviction may be sustained. Also, in a prosecution for murder, the state must prove beyond a reasonable doubt not only that the deceased died as a result of criminal conduct, but also that the accused intentionally caused the death with the requisite criminal intent, and that in an instant case, the evidentiary chain relies upon by the state contains several significant and irreparable deficiencies which created a strong, reasonable doubt that should operate in the applicant's favor. Hence, the trial judge was in error when it upheld the jury's verdict and ruled the applicant guilty of murder. Wherefore, even before the ruling of the trial court is hereby reversed, and the applicant will order immediately released from further detention. His civil rights, liberties, and other constitutional and statutory rights are hereby restored. The clerk of this court is ordered to send a mandate to the trial court commanding the judge residing into the resumed jurisdiction of this case in case of effect of this judgment. And it is hereby sworn, daily on our hands and seal of the Honorable Supreme Court of the Republic of Liberia, this 28th day of August 2026. Signed, Yami Kokobrese, Senior Chief Justice, Supreme Court of Liberia. Chief Editor, Howard Watercolly, Associate Justice, Supreme Court of Liberia. Joseph D. Kaba, Associate Justice, Supreme Court of Liberia. Senator E. Clinton Johnson, Associate Justice, Supreme Court of Liberia. Brother M. Cannon, Associate Justice, Supreme Court of Liberia. 17. Mrs. Sando, Parley, Holder, and others applicants, versus regular and Holder, and others believe in the petition for revocation of the state and legislative education and for proper accounting is called objection.
Well, just the federal hour of the party, you got what?
This is the public matter. The value estate of potential estate of the city. She died, and when she died, her nephew, managed the estates, and then he died, and then other team, that is the other before us, came to the guidelines of administration to manage the estate. Not the estate, but the guidelines of administration and finance. The nephew that was managing the estate, right? After he died, he became one of the administrators. But then she had to travel to America, she went to America. And so we have four applicants before us who continued, they went for the level of administration and the managed the estate. Now the problem is that before Red Holder Senior died, while before the initial administrator died, he had gone to a civil law court to initiate a complaint and rejected property his mother said on the estate property, and he won. He won. The estate was supposed to get an award of 300,000, but he went to court and the judgment was made paying 45% of the money down, and then later on, working for years to make stipulation paid balance. Well, the 25% is made according to the rule, the very good amount that started the property. They said the fairly distributed 25%. But apparently, the wife, who is the appellant or who appellant, started calling the owner, was dissatisfied. She said that these people were mismanaging the estate, and so there was this back and forth, back and forth. And she got another niece, Anna, in America, John, she will be company, and Anna John filed a petition. And in the petition, it was saying that the appellant, they should remove the appellant and put allow some, they recommended their lawyer to take over and manage the estate. And then they said, okay, perfect. So when the 2 weeks of the court, these two petitions for the court, the court decided to consolidate the account of the cat. The appellant said, no, don't consolidate the accounting with the removal of the president administrators. It's not proper, and the judge said, with that same party, same problem. So the judge decided that he was going to remove and consolidate. The matter is consolidated, then the judge told the court travel, and a judge was sent with the right to continue having to run the public court. In the meantime, the appellant said, oh, you waste time, the divorce, let's settle. And the tribe, the one said, the appellant would take the court, they didn't want to settle, and blah, blah, blah. So the one guy who was fine, he said, I think you should proceed in this matter because we have a problem. The money that we pay to the civil law court, the sheriff there getting the money. And the other people is because why this thing was going on the original judge of the public courts. That is, the judge the public court decided we're going to bring the estates under the public courts, managed by the capital. In the meantime, there was nobody who collected money apparently from the civil law court. So the sheriff taking advantage of all, since the sheriff taking advantage of the confusion, decided to do the. So these people want to say, we have to appoint somebody to manage his debt. So the estate that we able to receive the money as we and run the estate properly. The fact was decided to call the matter. The time to call the matter. We heard. The other people one thing was, we can't get the matter today because we are supposed to get an old issue. And the trial, we cannot go to get an old issue. So that's not just because they judge putting and assign this matter for hearing. So what the Lord should just proceed in the matter. But anyway, they decided they would postpone this matter and come back. They come back for the hearing of the matter. They gave their fellow to show up. They said that their witnesses, we get in contact with their witnesses, and all the instructed. So the judge decided to proceed on their case. And the judge decided that they would extend the letter of administration to the present administration, extend the letter of administration. So they will see the money to the estate, considering what happened before. So he extended it to propose their plans that usually is good. And the issue was whether the client would err in consolidating the petition for proper accounting, whether the client would err in proceeding to trial on the merits with all disposing of law issues, and whether the client would err in treating the offense forth at the time. Now, the first issue of the proper accounting in consolidating. You said we didn't know what the issue was because why the Senate wrote more. The administrator at the time, the letters of administration had expired and decided that the judge ever had brought the estate under the supervision of the court. And so there was not an issue anymore of letters of administration and issues for proper accounting. And this proper accounting is now the judge said, look, call for trial, first plead, the disapprove, and then cover the other three. And then the judge said, most importantly, after waiting 2 hours for you, your lawyer comes in, walk, the steering the court and walk out of the court. And we was disrespectful and said, but what actually happened was that the lawyer found they for continuance for filing the wrong post. And when they discovered they filed the wrong post and they came to file in probate court by that time, the probate court had proceeded with the head of the matter. Then whether the trial judge entering the take on the time and then the issue of law, it was a law, or they say hearing, and said, yes, they could say proceed to hear the matter to proceed with the issue of law. But we said cases where clearly from the past and circumstances, there was no pure issue of law. It was issue of law in fact. And so in this case, looking at the issue of law in fact, you say we want proper accounting and all that, no pure issue of law in that. So we looked at it and said yes, and said the judge that proceeded, and just we reported the case for hearing on the issue of law in fact that they say the pure issue of law. Although the circumstances did not see anything pure issue of law, there was no reason to overturn the case. And so we said we need to realize that the public court, having sending the letters of administration, so that's wrong because we say that the public court, the first is the public court authorities to appoint supervised administrators under section 5 and 2 of the judicial law as prescribed, and because the case is Fadela versus Fumo. There is a continuous supervisory power over the estate, and is not confined to confer letters only upon the specific person that the offender will ask, or say we want this person to be there. So you say that because the petition is put, and we put it that grants that petition, so you come to the Supreme Court because you say it's the power of the public force to supervise, looking at the parties that they who they want to give letters of administration to. It's the power, other than God. It's the power to do that. And so the public will decide to extend the letters of administration after having gone through the private visit. And God say, no, we should not allow it when we will not do anything. Very any serious thing that the administrator have done. And so in this case, we said, no, we will what? Approve the public court ruling. We said that in this case, we give them 1 year, and you know, all years typically for long now, for all the months. So there is kind of letter of petition given to the appellate way. Well, when that's ready for this setting is ready, they have 1 year to close the estate. 1 year they must close the estate. And that's the ruling of this matter that we uphold the ruling of the public court and say that the judgment will be read downstairs, the man will read the administrators start 1 year to close the estate.
This case was called for hearing councillors A. Wabodigi, A. Libusi Wabodigi, the Mohammed E. family of Sana and partners appear for the appellants. Captain M. Wickens read out the writing associate law firm appear for the police. Having reviewed the records and contentions advanced by the councils representing the parties and consider the relevant law applicable thereto and decided by a judge. There was civil procedure law revised code Title 1 Section 9.10.3 stipulates that where a pleading is amended after a responsive pleading has already been served, the responding party may amend its previous responsive pleading if such amendment is necessitated by the new matter added to the opposing pleading, and that the right to amend a responsive pleading is not mandatory. It is conditional and arising only where the new matter necessitates it. That where a matter is ruled to try a party that is not ready for the trial may file a motion for continuance subject to the discretion of the trial judge. The party's failure to file a motion for continuance or to appear for trial after return by the sheriff of a written assignment shall be sufficient indication of the party's abandonment of its defense, and in which instance the court may proceed to hear the plaintiff's side of the case and decide thereon or dismiss the case against the defendant. And in the instant case, the judge having made assignment for hearing on Monday, April 22, 2024 on the records, as well as the issuance of a notice. Consequently, the judge made no error when he proceeded to hear the rule on the case. Wherefore, in view of the foregoing, the ruling of the public court is hereby upheld and confirmed. The appellees are ordered to settle all financial obligations of the estate, make payment of all outstanding debts, and close the estate within 1 calendar year from the date the judgment of this court is read in the court below. The clerk of this court is ordered to send a minute to the court below, commanding the judge presiding therein to resume jurisdiction and give effect to this judgment. Because I rule against the appellants, it is hereby so ordered. Giving on our hands in the seal of the Supreme Court of the Republic of Liberia, this 28th day of August, AD 2026. Signed, Yamin Koko Bensi, Senior Chief Justice, Supreme Court of Liberia. Chief Senator Howard Wolokoli, Associate Justice, Supreme Court of Liberia. Joseph D. Kaba, Associate Justice, Supreme Court of Liberia. Senator D. Clayton Johnson, Associate Justice, Supreme Court of Liberia. Waka N. Cannon, Associate Justice, Supreme Court of Liberia. Mangani Fufana, Sino Monrovia, appellant for the tested estate of Miri Ware, Manchu, the administrator, at the appeal where the action of the judgment is called for judgment.
The Chief Justice will deliver the opinion on behalf of the bench.
Again, the action of the tenant and the official identity together. Very few. Our practicing have rested. The applicant getting to Canada, the motion, pray for applications. Under getting juror, and to a council consider the motion and the application go etc. Apparently, the judge who said the application go and let the president resume jurisdiction and so actually proceed with the administration order and investigate the in your instruction to investigate the you or she order that the report or any objection to the report to be filed within 15 days. Who was reporting out the family file additional prosecution. The joint head of echo and the mission is that you were instructed to file with you can not have file after community or the mission. What was that like? So the real the sort of put I call it the jury. And the jury had a full skill and returned a credit against the applicant. I mean, I'm expecting. And I don't know how to I put it. I mean, like the part people report. We simply say that one of the project commission arbitration we were agreed upon by two parties. In second, we have no authority or a procedure to deal with that. Investigate solving. I feel that I can go that party at the summer, the police apparently, first one that be the part, the to the best, it's called me, and to say everything is part of our energy, why people. And we got far, and died. We was proper, the Bible was not here to talk about this. Contrary to God, therefore, thereby, respect. Again, reminded to see in keeping with the arbitration procedure acceptable by the full of civil and our federal.
Thanks.
This case was called for hearing because the Amara Kennan of the CCA Johnson and Associates in country must appear for applicants in Lauren Nekula. Mommy S. Omar Jr., Virginia D. Kula Jr., Liberty Law Firm appear for the appellee. Having reviewed the records, heard the arguments and contentions advanced by the counsels representing the parties, and consider the relevant laws applicable thereto this year by judge. Chapter 64, Section 64.10 of the Civil Procedure Law requires the court to affirm an arbitration award except where a motion is filed for vacating or modifying the award. Chapter 64.11d mandates that a motion objecting to an arbitration award should be made in 30 days after the delivery of a copy of the award to the movement. And in the instant case, a submission by the court of the arbitration award to a jury for full trial and a denial of the appellant's objection to the arbitration report, which was filed within the 30-day statutory period. The lower court judge really was erroneous and contrary to law. Wherefore, if the foregoing, the ruling of the trial court is hereby reversed, and the case is remanded with the instruction that the lower court proceed to hear the objection of the same report in accordance with Chapter 64 of the Civil Procedure Law. The clerk of this court is ordered to send the manual to the court below, commanding the judge presiding herein to resume jurisdiction and give effect to this judgment. It is hereby so ordered. Giving on our hands and the seal of the Supreme Court of the Republic of Liberia, this 28th day of August AD 2026. Signed, Yamin Kwekwe, Senior Chief Justice, Supreme Court of Liberia. Chief Edward Howard Waterbury, Associate Justice, Supreme Court of Liberia. Yusuf B. Kaba, Associate Justice, Supreme Court of Liberia. CNN B. Cleveland Johnson, Associate Justice, Supreme Court of Liberia. Parker N. Cannon, Associate Justice, Supreme Court of Liberia.
Right? Okay.
Following on appellant versus the Republic of Liberia, the appeal to the Crown minor is called objection.
This version of the Parker and panel will speak for the court.
The branch jury of Omi County during the February 10th meeting 2022 indicted fully court and several others for the crime of murder. At the call of the case, the other suspects could not be found, so the defendant fully made a motion for a severance trial and was granted accordingly. During trial, the appellant requested for a bench trial but was denied on grounds that the trial was a capital offense. The both parties introduced witnesses and produced evidence in support of their theory of contention. At the end of the trial, the jury found appellant guilty, which was affirmed by the prior judge. From this judgment, the defendant accepted and announced an appeal to the Supreme Court. He essentially argued that the court should have found him guilty of manslaughter instead of murder. The testimonies of prosecution witnesses basically sought to prove that the deceased murder victim was arrested and fined by the county on allegation of speaking to another named by speaking for pushback. They were informed by the county who said that having investigated the matter and following the imposition of a guilty verdict by the elders of the town upon the deceased murder victim, he chiefly instructed his men to escort the deceased out of the town in that the said design to escort the deceased murder victim out of the town was only a cover-up for the appellant's criminally orchestrated plan to murder the deceased, which indeed when he murdered him during their journey to his hometown and threw his body in the Maher River. This would have established his standard for prosecution must meet. This could have established his standard prosecution must meet to find the appellant guilty of murder by circumstantial evidence which deemed it necessary to restate that the state did not directly link the appellant to the commission of a crime of murder as charged in the indictment. Accordingly, we hold that because the state circumstantial evidence stated upon evidence by the chief needed to lead any reasonable man to the conclusion that the appellant did murder through genetic preparing prior court's finding final ruling as to the charge of murder, the response supported by the evidence and the concluding laws was wrong. We therefore reverse prior court's final ruling and order the appellant to release on any further details. This is our decision.
When this case was called for hearing because William O. Johnson appeared for the appellant because RCC Fire Solicitor General Republic of Liberia and because Richie J. Scott Kanda was only most of the county Ministry of Justice involved Liberia appeared for the appellee. Having carefully examined the facts contained in the records, listened to the arguments of both sides, and considered the evidence, the law relevant thereto to proceed by a judge. It is the law that in order for the state to convict an accused of a crime, the prosecution will prove the guilt of the accused beyond a reasonable doubt. The mere allegations do not constitute proof, and the allegations made in an indictment must be supported by evidence, as it is only evidence which enables the court to determine with certainty the matter of dispute. And in this case, the prosecution's evidence having failed to convincingly establish that the appellant participated in the killing of Joe Jenikin, the final ruling of the trial court finding the appellant guilty is hereby reversed. Wherefore, in view of the foregoing, the final ruling of the trial court adjudging the appellant guilty and sentencing him to life imprisonment is hereby reversed. The trial of this court is ordered to send a mandate to the court below, commanding the judge to resume jurisdiction of this case and give effect to this judgment. Court is allowed, it is hereby so ordered. Given our case in the seal of the Supreme Court of the Republic of Liberia, This 28th day of August 2026. Signed, Yami Kokoblaisi, Senior Chief Justice, Supreme Court of Liberia. Chief Editor Howard Watercolly, Associate Justice, Supreme Court of Liberia. Lucy B. Kaba, Associate Justice, Supreme Court of Liberia. Sienna D. Clinton Johnson, Associate Justice, Supreme Court of Liberia. Oda N. Cannon, Associate Justice, Supreme Court of Liberia.
Next.
The Sonochi Pularo Doma is a judge, still on our court, Mr. Mali Paul Kamara, petitioner was Ms. Mami K. Kefi, and others responding petition for re-argument, discover judgment. Yes. Judgment of our opinion. Whereas the co-petitioner, Ms. Mali Paul Kamara, instituted an action of summary proceeding to recover possession of real property before the civil law code for Marshall the county against the respondents, Mohammed K. Kefi, or person occupying the subject premises, seeking to recover possession of property which he had acquired through a judicial sale. Whereas the respondents filed a motion to dismiss the action on the ground that they were lawfully occupying the premises pursuant to a lease agreement, which motion was denied by the trial court. Thereafter, the respondents petitioned the Chamber of Justice for the Honorable Supreme Court for a writ of certiorari. The Chamber of Justice granted the petition and reversed the ruling of the trial court, from which the petitioners announced an appeal to the full bench of the Supreme Court. Whereas, after hearing the appeal, the full bench confirmed the ruling of the Chamber of Justice. Subsequently, a petition for re-argument was filed approved by the concurrent justice, whereupon the clerk of this court redacketed the matter for hearing. Whereas when the petition for re-argument was called for hearing, it became apparent that Associate Justice Senator Clinton Johnson and Associate Justice Michael N. Cannon had not been members of the Supreme Court bench at the time the original opinion of judgment were rendered. Additionally, former Chief Justice CNN G.O. had retired from the bench before the court heard the petition. Consequently, only two members of the original panel remained available to hear the petition for re-argument, thereby leaving the court with a quorum to determine the petition. Now, therefore, it is hereby ordered: 1. That the opinion and judgment of this court rendered on August 27, 2024, in the appeal arising from the petition for a writ of certiorari out of which the petition for re-argument is hereby called. 2. That in view of the absence of the quorum required to hear the petition for re-argument and to afford the two associate justices who have since joined the Supreme Court bench an opportunity to participate in the determination of the controversy on its merits, the judgment of August 27, 2024 is hereby called. The case redacketed and the petition for re-argument order was June is stricken from the docket of this court. The appeal is hereby ordered and you before the present bench. Giving on our hands in the seal of the Supreme Court of the Republic of Liberia, this 28th day of August 2026. Signed, Chief Editor Howard Watercolly, Associate Justice, Supreme Court of Liberia. Lucy B. Kaba, Associate Justice, Supreme Court of Liberia. Senator D. Clinton Johnson, Associate Justice, Supreme Court of Liberia. Oda N. Cannon, Associate Justice, Supreme Court of Liberia. Lord Chief Justice Yami Kokoblaisi, having recused himself from the hearing of the appeal, and seeing emanating from his ruling day while presiding in chambers, he did not sound this judgment. Lawrence Hill and others find appealing and tested as a covert counsel second appellant was Cecilia Tor appealee appeal out of action on the judgment is called for judgment.
If the president will deliver the opinion on behalf of the bench,
Again, the High Court hearing, regularly required, change, the applicant, hearing, prosecution or investigating something. You have to consider the investigating something. And this is what regular law, the court committed the court, the court orders the jury, trial of everybody held without action, the ruling, value of the crime, the final ruling entered by the full group will follow up and forget the subject agreement by another of the fees in this court. Review the record. Said that the video with the deletion of 110 levels of the presence of two bodies of representatives where there was no attention, no items going to the jury, who are private issue, for currently the president of issue, why I was to watch it and
when this case was called for the local council appeal for the applicant for the Amara and Senator Labour Law for the appeal for the appellee, having reviewed the records, heard the arguments and contentions advanced by the council representing the appellee, and consider the relevant law applicable thereto this year by a judge. The way an investigative survey is conducted and the parties' technical representatives were present and registered, no objections to the investigative survey process. The report of the survey is deemed to be correct. And that when the jury, who is the trial facts, receives an investigative survey report together with other species of oral documentary evidence, deliberate and return a verdict, which is confirmed by the trial judge as in the instant case, there is no legal basis to disturb the findings of the jury. Whenever you build the foregoing, the final ruling of the lower court is affirmed. The clerk of this court is ordered to send a message to the court below commanding the judge presiding therein to resume jurisdiction and give effect to this judgment. It is hereby so ordered. Giving honor our hands in the seal of the Supreme Court of the Republic of Liberia, this 28th day of August 2026. Signed, Yamin Kokwe Senior Chief Justice, Supreme Court of Liberia. Chief Senator Howard, local Associate Justice, Supreme Court of Liberia. Joseph B. Kaba, Associate Justice, Supreme Court of Liberia. Senator D. Johnson, Associate Justice, Supreme Court of Liberia. Parker M. Cannon, Associate Justice, Supreme Court of Liberia. Urban marketing by issue at the round for dismissal, Cedric Inuga, respondent, and then testing estate of Joel Department, just on responding. Motion to dismiss appeal is called for judgment.
This motion to dismiss appeal for urban marketing by and through Mr. Allen Brown against the appeal of Mr. Cedric Inuga and the interstate estate of Monrovia by and through his administrator, Malita Elizabeth Topman, Kevin Waters, first and second respondent respectively. The movement contention is that respondent did not fulfill the mandatory requirement of the approved statute for the perpetual appeal. That the respondent announced an appeal, filed a separate bill of exceptions, or failed to file the appeal bonds in notice of completion of appeal. In resisting the motion to dismiss the appeal, first respondent Cedric Inuga contended that in November 28, 2025, final judgment was entered by the trial court in the declaratory judgment as in favor of Organ Market that on the same day, November 28, 2025, where the respondent filed a motion to receive judgment and was granted on January 9, 2026. That the trial court judge, having vacated the ruling and relieved the first second respondent of the judgment, there was no legal basis for the perfection of an appeal. As the second respondent, it did not buy any resistance. A review of the records showed that the bill of exception for the first respondent was approved by the prior judge on December 8, 2025, and that of the second respondent on January 12, 2026. That it was after the approval of the bill of exception that the prior judge proceeded to receive judgment. That this group maintains that while the prior judge has the right to receive his judgment within term time, it cannot do so after the bill of exception has been approved. Accordingly, the motion to dismiss is granted for respondent failure to perfect the appeal. If it's our position.
When the case was called for hearing, Councillor Simmons and Renan Cephas of the DASA consultants say in appear for the movement. Councillor J. Johnny Momo of the J. Johnny Momo Associate Legal Team must appear for the respondent. No counsel here for the second respondent. Having carefully examined the facts contained in the record, listening to the arguments on both sides, and consider the evidence and the law relevant thereto, it is hereby adjudged. The civil procedure law revised for that was 151.16 provides for the dismissal of an appeal for failure of the applicant to comply with the mandatory provisions of the appeal statutes. That it is the law that the signing of the bill of exceptions removes the case from the jurisdiction of the trial court except for ministerial acts of approving the appeal or of opinion to challenge, and that the applicant's failure to file their appeal bonds and to serve to file their notice of completion of appeal as per the dictates of the appeal statute constitutes the ground for the dismissal of the appeal. Wherefore, in view of the foregoing, the motion to dismiss the respondent's appeal is granted and the appeal is ordered dismissed as a matter of law. The clerk of this court is ordered to send a minute to court below, commanding the judge presiding therein to resume jurisdiction of this case in case effect of his judgment caused by a rule against the respondent, and it is hereby so ordered. Giving on our hands in the seal of the Supreme Court of the Republic of Liberia, this 28th day of August 2026. Signed, Yami Kwekwe, Senior Chief Justice, Supreme Court of Liberia. Yusuf B. Kaba, Associate Justice, Supreme Court of Liberia. Senator D. Clinton Johnson, Associate Justice, Supreme Court of Liberia. Waka M. Cannon, Associate Justice, Supreme Court of Liberia. Agreement by and swap by the state of the applicant for the Scenario Parker affiliate, the big word of action of judgment is called for judgment. I'm for the floor.
This appeal exposes some of the elementary errors that are committed by lawyers and judges that result in necessary pay of every single case. And it's a plastic. It's the appeal hearing instituted action of judgment against the applicant. And when the complaint was filed, the applicant immediately filed the answer. The answer was immediately filed, although the answer contained vision by the applicant. The counsel for the applicant filed a motion to strike out the answer that contained the admission. So the court proceeded to strike out that answer. When the answer was stricken, the applicant was on bare denial of the occurrence in the applicant's complaint. But whenever another judge took over from the judge who struck out the answer, that judge also gave a ruling matter of the trial, although there was no answer in the fact. Still, whenever the applicant's lawyer proceeded to file a motion for summary judgment based on the occurrence in the stricken answer, and then the court came and granted the motion for summary judgment. It is that ruling that was appealed to this court. And the elementary thing is, how can you use a stricken answer as the basis for filing a motion for summary judgment? Who said the judge was in error for granting that motion for summary judgment since the law was compared in error? And then what should have been seen in this case was for the appellee to have perfected the judgment by producing evidence, while the appellant should have been denied the right of producing affirmative defense against himself. So we return the case back for the appellee to be given the opportunity to produce evidence basically and successfully of the complaint. So that was our judgment.
When this case was called for hearing, Councillors T. Emmanuel Thomas and William F. Dow, Femina Obis and Associates may appear for the applicant. Councillor Fester K. Noah of the University of Law Partners may appear for the appellee. Having heard the arguments, review the facts and circumstances revealed by the records, and examine the law controlling initiated by a judge. That it is the law in this jurisdiction that striking the defendant's answer places the defendant on bare denial and renders it as though the defendant had not filed an answer. The bare denial, however, does not preclude the plaintiff from producing evidence to substantiate the affirmance in the complaint. And in the instant case where the appellant's answer was stricken, the trial court's subsequent granting of the appellee's motion for summary judgment constituted irreversible error. Wherefore, if you have the foregoing, the ruling of the trial court is hereby reversed and the case remanded for trial on the appellee's complaint. The clerk of this court is hereby ordered to send a mandate to the court below, commanding the judge presiding therein to resume jurisdiction over this case and give effect to this judgment. Cause to abide final determination in this hereby sought. Given on our hands in the seal of the Honorable Supreme Court of the Republic of Liberia, this 28th day of August in 2026. Signed, Yami Koko Vice Senior Chief Justice, Supreme Court of Liberia. Chief Senator Howard Wolofadi, Associate Justice, Supreme Court of Liberia. Yami Yusuf D. Kaba, Associate Justice, Supreme Court of Liberia. Senator E. Clinton Johnson, Associate Justice, Supreme Court of Liberia. Walker M. Cannon, Associate Justice, Supreme Court of Liberia. The management of SOS Children Village, appellant versus Augustine A. Aniu, appeal petition for judicial review is called for judgment.
I'm not interested. That's how everybody would think like it's what.
Mr. Labor Backup, the appellant, I know, a person argued, filed against the management of experts for the village. Okay. The alleged that was dismissed by SOS. The SOS people have originally opinion this letter. One of them was that he had assaulted one of the employees of the staff of SOS. Sexually assaulted, you see that. And that there was use of body bullying, or bullying that he used to bully the staff, and he made a location where he said the staff decided to have some party for one of his members, and he came there and went where the salary was suspended. Then there was an issue, mismanagement of the funds, and even the finance, the office of the even the manager of the they have something where you take salary advance. And when you take salary advance, he had your proof. And he had to approve the salary advance, so they gave the policy that they had. Now the question that comes to play is that within the manager, when he wanted salary advance, how to get the salary advance. From reading the records, it showed that he had get approval himself from the overall board that did not need in Monrovia. And the evidence that they wanted salary advance, he approached or wrote a letter requesting that he wanted salary advance to be attained to from it, and she approved it and got salary advance. But the following years of school, I got 3 of them with one, and they seek my approval for salary advance, just kept on giving the salary advance for himself 3 years thereafter. So they put that in the death of this as mismanagement or the expectation. So we went through, he said, well, looking at the document, he said that he agreed this with them and that. He said, well, maybe I should much evidence, and if he was head of the organization, and he felt that it was wrong for you to come and have a party when they had, when the business operating to me, they started operating the hospital or the office. It was wrong. Without getting this permission, we said, that's a decision people were taking. Then it came to the statutory rights on the corner, and that this thing had happened about 3 or 5 years before, when this lady had reported it, and just was done nothing. So why was this now taking the step at this time? But what we found in the record was, indeed, as well as that quick, that there was mismanagement of his own value, because you are the organization, you want to yourself, say, well, I am the organization, I have the right, I'm the last person to sign, and so I have the right to take in and approve my own salary events. You said, looking at the record and what I described before, and looking at the policy, there was mismanagement of the funds, and we agree with FAS that it should not have done that, and that the FAS will not go and have been dismissed just for the management of funds. And so based on that, we whatever we have realized this under the forms and the interpretation of God's property. That the essence of this case. Knowing the
Well, this case was called by Aaron Kazna Evangelist Sina of the Heritage Partners and Associates LST appear for the appellant. Councillors Rami Bagha and CNN and fixing of the homeland law Chivas appear for the appellee. Having reviewed the record, heard the arguments and contentions advanced by the councils representing the parties and consider the relevant laws applicable thereto in this year by the judge. Are consistent with section 14.3a of the Dissolution Act 2015, an employee may be immediately dismissed by his employer where there is a showing that the employee's conduct makes it impossible to continue the necessary employment relationship of mutual trust and confidence. And in the instant case, the appellant having immediate knowledge of the allegation of misconduct for sexual harassment against the appellee following the alleged occurrence of an incident in 2017 and maintain its employment relation with the said appellee until 2022, they have condoned the appellee and therefore waive its right to immediate terminate as envisaged by the statute. Thus, the dismissal for misconduct on that basis was illegal, untenable, and however, the appellant having proved that the appellee was dismissed for administrative misconduct when he took 3 salary advances for himself without the approval of his supervisor, his conduct amounted to the breach of the appellant's administrative and financial policy. It therefore renders his dismissal by the appellant proper and legally consistent with the Dissolution Act. Wherefore, in view of the foregoing, the ruling of the National Labor Court confirming the hearing officer's ruling that the appellee was wrongfully dismissed and entitled to an award of United States and $1,000 thereby modifying the hearing officer's ruling, seen is hereby reversed. The threat of this court is further to send a mandate to the National Labor Court commanding the judge begging to resume tradition gave effect to this judgment. Court rule against the appellee and it is hereby so on. Keeping on our hands and the seal of the Supreme Court of the Republic of Liberia, this 28th day of August 2026. Signed, Yami Koko Maise, Senior Chief Justice, Supreme Court of Liberia. Chief Etaha, Associate Justice, Supreme Court of Liberia. Joseph D. Kaba, Associate Justice, Supreme Court of Liberia. Senator D. Clinton Johnson, Associate Justice, Supreme Court of Liberia. Rebecca N. Khalil, Associate Justice, Supreme Court of Liberia. J. Funatu Kofa Dixon to the civil and others petitioner versus Honorable Secretary Willie Resident Secretary Judge Criminal Assassin's A, first respondent, and the Republic of Liberia and Ministry of Justice, second respondent. Petition for the writ of prohibition is called for judgment.
The Chief Justice has said, was never the opinion on behalf of the bench. Let's say,
every house. But where like that, I'm the only. This might have to be more than what from the green day by the guest, the planning, is on the Muslim call. The planning of the crime, by the government, or the funding, his overview already necessary of the resilient impact Everything is my this is he when the persecution coming on like you really like the Quran, at the Paul Williams, hearing for the crimes of crimes of Adam, criminal leadership, criminal conspiracy, criminal sedition, criminal intent to commit murder, aggravated assault, illegal possession of firearms, the release of property forces, residency in Liberia, corporation, and theft of property. The movement were arranged and they pleaded not guilty to all charges and therefore joined into the state. Once to manage the state, King ordered the legal duty to take beyond it is again, removing beyond a reasonable doubt. On July 2025, when prosecution made a work or the qualification of 85 witnesses, the respondent including red flag or red table witnesses, through the witness stand and testify that he is an assistant commissioner of police and testify to the area, audience, and bishops in the good fact. Made his testimony testify to the last day for key to this case is a particular statement you made to a question posed by your issue that is history, which we go back. Question. Mr. Willie, during your testimony, also the audio that you presented to us, the time day of your testimony, you brought a photo and you did display for us to see on the board. You identified some of the defendants in the document, saying that they were planning to break down the cabinet. You want to take up the order that there were no CCTV cameras. How did you manage to get the photos that you presented to us? Question, example, answer, example. So there are several photos that were displayed on the first day of my appearance before this court. One of several photos shows that you have the outside of the Capitol building. Another photo shows you how the young chamber was looking on the side of the building. Another photo shows you defendant children participating with other police on that Sunday during the dissolution of the Grand Chamber. How that photo was taken from his phone. Another photo show you the place of fire. One of the place fire was obtained from the defendant's phone. It was shown. It also showed you the honesty, and how damaging room is, meaning the Grand Chamber. The photo and the room area. In between, the investigator will be given access to the affected area. This photograph. Another photograph shows you where the photograph and the matches were, and it was also taken by the investigation during the discovery of the said potential. So this also a plural of with another person potential office. Mr. Willie, can you please bring the photo so we can see it? Because of me, I did not identify anyone on that photo. Potential office. The witness display a view on the next week after permission from the court. After the video was displayed, the same juror made this follow-up question to Judge Willie. Mr. Willie, on the photo you just exhibited on the screen, the person looked like a Chinese, and what I saw as evidence are the same question with Judge Willie. What follows this? What follows this is the center of the controversy here. After this question by the juror, the witness made a following remark to Judge Willie. The juror gave you not to say I'm already fallen again by making it clear that the photo in the video does not represent Thomas Willie, but the Chinese. While this prosecution agreed with Willie interpretation of the juror and then found also identified the court that this question was dramatic and that it showed that the juror in question had already formed a final opinion about it. The prosecutor then prayed the court for the statement to be recorded on the meeting of the court. Thereafter, as the court of the case commanded the court to testify, the prosecution, while making its representation before the court, that it had the submission to be on the ground. After the witness had made its representation, the prosecution was called to make his submission. The prosecution in this submission accepted that the entire power of trying to jurors, in this case, has demonstrated and we are grateful to render combined independent and impartial that really never several jurors openly concerned among themselves and the same questions before posing them to the prosecutor. That one, the end reflect a lack of independent judgment and powers. The center of juror preparation and impartiality settled in section 19 of the Juror Procedure Manual that the appropriate was there and partial withdrawal against us was a thing. The impact confirming impropriety of their behavior that these items have contaminated the group panel, the group panel, and render legally disqualified. The anti as a teaching example, the owner of Europe, JP, not necessarily, who requested a day of the video requiring the man after reviewing a spread opinion to this statement that the individual's phone low like a Chinese and not even that this statement constitute premature formation of the final opinion while he was still being presented. In application of the Bureau to maintain open mind until delivering, the prosecution concluded that the jurors were electrical concerning what is called achievement and forming premature opinion demonstrates partiality and inability to carry a dictate matter. Prosecutor therefore requested through their submission that the entire narrative is granted and agreed to preserve the integrity of crime. The petitions created in resisting the submission made by the prosecutor after the prosecutor motion to dismiss the entire matter is legally binding. Also put by the record and constitute and warrant attack on the following civil duty. That the prosecutor will deliver the state bureau misconduct rely on them obey calculated claims such as alleged no pass consultation among the jurors. And the jurors have never read on the record or brought to the full attention when they supposedly correct that regarding drug, James ruled out simply that the defendant already that the prosecution must use it. The juror remarked that the record shows that the juror ended this point with the question that are these two people, the one in the view and the one in the letter, are they the same person? Which the defendant as the legitimate background you have right in the previous conclusion. That even if based on the so the defendant argued that he actually not broken and not be included to the entire one. That then no evidence of any juror being biased, infiltrated, or contaminated. Especially that the juror are requested order to carry on the security that the prosecution allegations are not fully unfounded, but implausible as the defense has no access to the juror, whereas the prosecution controls the police investigating apparent that the prosecution of the prosecution improperly did most of the people in the presence of the jurors, and an act they describe as great infinity and designed to ransom after the defense for examination as a supposed movement in a prosecution case. That is unfounded to suggest that the trial judge or the misconduct of the juror as no such record and when it said commission improperly make the post a partisan with that the constitution has started working like authority over that to the core of the juror to justify the government and that the only permit program manifested necessary necessity has not been shown. Manifested cannot be shown. Therefore, the finding the jury may have be unprecedented, unprocedural, as a very prejudicial to the defendants who are already obtained. The defendant completed the court. The defendant completed the court that the motion be denied and the trial order considered with the prosecution be able to do in that minute. After the commission was made and the resistance as protocol, the trial judge entertained argument and thereafter ruled they would disband the jury and order the new trial. The trial judge ruled that juror James United in pieces 950 did more premature and prejudicial opinion during juror questions. The judge also determined that the statement being added by the whole prosecution and the defense to bring the motion are motion and resistance while the juror was present were inflammatory and violated the field of the code of program and ethical conduct of the law. The statement that described juror as informative was all the judge of a chest-like juror being capable of sharing strong emotion and alternatively be final. Because of these remarks, requiring the whole people in the juror person in the court concluded that the trial for there has been compromised. The judge then granted a submission as made by the prosecution, granted the jury and ordered the trial. made some case findings. The court ruled that the entire jury panel has been compromised. Declared in this trial and ordered the jury disbanded. A new trial was there to commend afresh. Primarily on this ruling, the defendants who are particularly hearing through their legal counsels accepted and filed a petition for a writ of prohibition before the chief magistrate. The chief magistrate, upon receiving the filed petition, forwarded the matter to the court defendant for examination on grounds that the constitutional issue have been read in the petition. The petitioners gave over and all in their petition for a writ of prohibition contended that the trial judge erred in handling the prosecution motion to disband the jury and to order the new trial that seal should be undrawn. Because the said action of the trial judge are unlawful and illegal. The argument after the jury was duly selected, qualified, and in part of the trial commenced with the prosecution that the witness was examining and the charge according to law. That three jurors questioning, one juror sought clarification regarding the identity of the defendant depicted in the video played in open court. That constitution interpreting the juror question. The person are seen in the video look at the challenge that are they the same question as evidence of bias and immediately go for the entire independence. The petitioner resisted arguing the alleged conduct of the single juror who changed the entire panel. There are no evidence supposedly of juror misconduct under the prosecution accession amounting to speculation that the prosecution failed to demonstrate manifest discipline. The only lawful basis for according to the criminal trial one, Judge has attacked that despite the decision of the defending judge granted motion, the defendant set aside the proceeding and declared mistrial. The petitioner further argued that the judge really was based on grounds that he independently injected into the case rather than on any issue properly raised by the party. The court argued that the trial judge improperly attempted to create official judicial review by suggesting that this successor will be bound by this characterization of the event as manifest necessity. The petitioner then invoked the procedural law code 116.22, which authorizes prohibition not only to restrain unlawful judicial action but also to undo act already done illegally. They rely on precedent as held in the court in previous opinion that prohibition will lie to reverse the judicial action taken without jurisdiction or in violation of law. The petitioners then prayed the court to grant it and declare the trial action as illegal, unjustified, and which prejudicial, and that the mistrial should be clear and that the petitioners be the child of all answering the indictment as any subsequent trial on the same child will be constitutionally bad. The responding parties return to the petitioner in response. They argue that this court to deny the amended petition by the writ of prohibition on the ground that the trial judge decision is to disband the jury and declare this trial was not exercise of judicial discretion, rather friendly in the doctrine of management. The respondent contends that the petitioner have failed to demonstrate any regard or to a reasonable effect that will justify the issuing of the extraordinary provision. There is very argument that the record revealed that during the playback of the video evidence on the 37th day of grace in Nigeria during the June said openly stated that the individual depicted looked like a Chinese man and inquired whether that person was saying at full evidence. The response of this that the statement constituted an impermissible prejudgment or the material of the material fact, meaning the identity of the accused prior to the close of the evidence. All Lord, the juror must refrain from forming or expressing any conclusion until the case is submitted for deliberation. The trial judge rightly called the juror, and made up his mind as to position before all the evidence was presented. A finding which is supported by the record. The responding party indicates that some jurors were saying that changing notes and concerning about themselves. Although these allegations were not documented, the trial judge considered these behaviors as part of the totality of the circumstances underlying the impartiality of the crime. The trial judge was not required to wait for a compromise before acting. The respondent maintained that the trial judge acted within the scope of his discretion in concluding that the integrity of the proceeding has been compromised and that continuation of the trial will not guarantee a fair and impartial verdict. The petitioner has said that the trial judge improperly reviewed new specifically introductory by counsel to justify mistrial. The respondent denied this petitioner argued that the judge merely referenced the problem context in which the juror misconduct occurred. The judge did not rely on counsel's statement as an independent basis for his finding, but rather considered it as part of the factual matrix forming his assessment of the prior offense. The respondent for argued that allegations that the trial judge exhibited violence or suffered to reactively by the double guarantee claim is contemptible, stating that the judge's comment regarding the potential impracticality of double guarantee were legal observations flowing not only from the finding of the manifest necessity and the successor judge remaining free to assess any issue double guarantee plea. The respondent provided that prohibition is special proceeding capable of restraining or undoing illegal judicial act. However, prohibition will not lie to correct mere objection or to review discretionary ruling where the judicial court act of being issued. As such prohibition will not issue where adequate remedy by the PSC. The prior court possessing unquestionable jurisdiction over the criminal offenses charge, and the judge's ruling was the reason having to go to establish legal principles governing mistrial. The respondents submit that the petitioner have failed to demonstrate any illegality or usurpation of judicial power. According to prohibition cannot be used to undo a ruling that was ruled discretionary and supported by the record. The respondent prayed that the petitioner will be denied an alternative reason, court and the matter order proceeded consistent with law. We have scrutinized the petition and the return and other evidence and records certified to this court and the issue that is the possibility of this controversy is whether or the victim circumstances and the fact that any issue prohibition will lack. They have argued that prohibition is the appropriate remedy under the Chapter, while the prosecution respondent argued that prohibition will not lie under the Chapter. We start by defining revisiting the historical nature and function of the writ of prohibition according to our jurisdiction, in order to have a fair appreciation, understanding of the extraordinary writ. The prohibition is among the oldest extraordinary remedies known to the common. Long before the development of all active practice, the miracle visualize the ritual restrain inferior tribunal from exercising power beyond those conferred upon them by law. The purpose of the rule was not to provide litigants with the convenient means of correcting judicial mistakes, or to preserve the proper distribution of judicial authority and to prevent inferior from restoring power belonging elsewhere. Liberia inherited this understanding through the adoption of the common law and later qualified this break in the civil procedure of Liberia. The civil procedure law, chapter B, section 16.213, parenthesis defines provision as a special proceeding to obtain a written order responding to refrain from further pursuing a judicial action or proceeding specified therein. The spirit of the statute is clear and unambiguous. The purpose of the writ, as seen from the definition, is that the writ exists to restrain or prohibit certain action or proceeding. One of the early authorities on the nature and office of it, the interview by the who was in the case of Papa in 1925, where this court has found the foundational goal prohibition and operated on two grounds. First, where the Imperial Code Act would violate judicial over. Or second, where the code, although possessing judicial intent to proceed by rule different from those which ought to be there at all times. The code went further to say that this bill is never allowed to set the gate of usurpation, either author of power and abuse of power. The father was worried who the five and five. Our contemporary and more degree reported on the office and risk of the writ of prohibition rest on this fundamental code as espoused by the code in the above case. It is clear that in determining whether the petition for the writ of prohibition will lie, the court was always draw and distinguish the thing now to jurisdiction, sufficient, and mere ordinary Israel. The court has also been declared, making it to properly distinguish between inferior acting without authority and inferior exercise in authority, whether improperly or erroneously or not, and I consistently hear that in form invite conditions. The legal appeal review or some other remedy legal law. The principle was further reaffirmed by the court when it held in the case who case was in Java 20 hours 3, The prohibition of preventing inferior code or tribunal from exonerate religion regularly vested in them. They cannot correct error and irregularity committed are trial for adequate and complete remedy, therefore lies in a plea, rate of error or self-crime. The work has been defined by the code given in our contemporary dispensation and has been further interpreted to mean an extraordinary issue by the appellate code to prevent or restrain an inferior code or administrative tribunal from taking action in case for which it does not have it, or whether it acts beyond its jurisdiction or attempt to perceive a new different from those which ought to be observed at all times. This is Daniel 1 of the Supreme Court of Liberia, 2022. Having established the order of prohibition, it is obvious that the next step of our inquiry is to examine a trial judge ruling to disband a jury to determine whether it was in the exercise of his lawful authority. Finally, we think it is expedient to point out that the petitioner hearing do not challenge the trial judge jurisdiction over the subject matter as such challenge amount to have due authority, nor would the particular challenge the trial judge jurisdiction over the present action would be proportional on the expired term of the hearing. The primary argument advanced by the petitioner in the petitioner before this court is that the trial judge ruling disbanded the jury and ordering a new trial on the ground that the jury is compromised and therefore will not make a fair decision is erroneous and therefore the judge should be prohibited from proceeding further with the matter and that what you have done should be or do to look down through the office of prohibition. This can be no matter how successful it may be or it may sound, and challenging the decision made by the judge within the exercise of the lawful and legal authority. So assuming that the ruling of the trial judge which the petitioner allowed entering through the petition for the way of the law was erroneous, his determination would not be there. Such decision was done within the exercise of lawful authority within the confines of an appropriate jurisdiction. The court where the case is being tried has been over the party and the subject, and our law are clear that the trial judge may disband the jury if he genuinely believes that there is jury misconduct or other issues which will make it impossible for the jury to reach a fair or final decision or good 12% of 222-1. Our case law is also repeated on the issue that it is an elementary principle of law that the trial judge is under mandatory duty to immediately suspend the trial and conduct an investigation whenever an case of duration present are raised, and depending on the bound is bound, the jury and award a due trial. Law accorded. We look at the section, we immediately argue and contend that the prohibition can do what was illegally done, and therefore prohibition was improper order. This would allow and confirm the prohibition can do what was illegally done. Now, in the ancient day, where the jury has been disbanded and a new trial awarded, what would have been unknown by the prohibition? Question. So we have to look at the teaching of the rate of prohibition is granted. It will be awarded untenable for the judge to recall and re-empower jurors who have already been discharged and have reintegrated into community. Such preposition is not only legally concerned but also benefit is because the root that the children have can include the big of it. So one random within the body of the law. The old activity of what practice and what the subject matter and did not receive by the law with everything with it. Immediately by dry coat was not clear how the law to judicial. We are now asking question whether the law really was interlocutory or not. To answer this question, we now turn our attention to the beginning of the court on the 29th day of October 2006 when this matter was heard. The traveling question goes to the bench, goes by the bench to the one example for petitioner, and the answer provided to so as to provide further clarity of our holding this case. Question: why prohibition? I bet you why prohibition? Answer by the lawyer. The issue was the final judgment as a very would not have been the proper rule of action. Final question: why was an appeal not allowed? Answer by the lawyer. We couldn't have appeal. Question: didn't the petitioner want a review of the judgment decision? Answer: we want a declaration that the judge action was corrupt. This kind of answering shows that the petitioner are on a fishing expedition. If they that he said the decision of the trial was followed, why did the left come by remedy or rather acceding to have this would declare the ruling of the trial judge on law in which we have already determined is brutal. The decision of the trial judge was not found. The final ruling of judgment, this would have had a bonus determining and disposing of the whole level of the court before the court by declaring that the period is or is not entitled to recover by remedy or which completed and finally dispose of the break of the court which is separate and distinct from the fact thereof. There is one which terminated the litigation between the parties on the merit and did nothing to be done except imposed by execution or what has been done. The law is read. And another thing on the other hand is one which lacks finality, one which is rather in the middle of the court of some plea, proceeding or default, on which the only unique individual and does not finally determine or complete the suit, and that the judgment is in the rubble when it gave the court the final decision. For the purpose of ascertaining the matter of law or fact, referring to a final judgment or which determines some preliminary or subordinate point of plea or settle some step, question or default arising in the process of the case, but does not adjudicate the ultimate right of the party or finally put the case out of it. The law is also good. This would have also held that if the inferior court or tribunal has jurisdiction or both the subject matter and prohibition will not have to correct error of law or fact for which there is the adequate remedy by plea or otherwise, whether such error seen or have been actually committed. Two versus Randall that invited our 27 and 6. The council was there with concern that the trial judge ruling disbanding the trial unit did not primarily focus on the substance of the prosecution application. Rather, it characterized the misbehaving behavior on court and on general behavior of lawyers in the bar and their pronouncing which they have been playing, which they are employing the trial that will contrary moral and ethical conduct of lawyers. Rule 23 of the Code of Moral and Ethical Conduct of Lawyers provide all attempt to quote the favor of the inquiry jury by offering flattery or return solicitors for their personal or legal comfort during the trial or the case are unprofessional. The defense will never correct privately with the panel or any member thereof before the return of the verdict, and both before and during the trial, he should avoid communicating with them, even as to matter following to the case. The lawyer should avoid entertaining or correcting favor to members of the marriage during the year of the case, or immediately after the jury has returned a verdict for his trial in which the king his term is incident, and in a matter case above to be regarded with professional suspicion. Hence, the willing ought to have been friends in love to recognize the lawyers involved some misbehavior so as to deter them from future care. This court warned the lawyer representing the court in an attempt to influence the judgment of the court or to holding the enemy. We need not endeavor to the fact that this ruling made by the trial court is not only within the extra of the local authority, but it is also not the final judge or act, but in a lovely way as the indictment which brought the petitioner on the religion of the court is still acting and pending before the court and the trial judge in the ruling order the new trial which being matters still pending before the court. Therefore, the teaching law, therefore, the petitioner argue to have this court treat the ruling as a panel is unpersuasive and defeated by the failure to announce on the key if ruling was final. The civil procedure law, again 115, provides that temporarily is a special proceeding to review and correct decision or official who or agency acting in a judicial capacity or to review an intermediate order or the ordinary judgment of the court. More parties of law have found that the writ of secretary is for the purpose of correcting errors of legal by the ordinary court or other parties while the matter is pending. And such error material prejudice or injure the right of the party. This is clear. In a we made by imperial court are subject to review through the petition for the writ of secretary or a remedy for sending black British. The other of the not lie for prudence that may be redressed in the ordinary course of judicial proceeding by authorities provided by provisional can clearly grounded in cases or manifest where other relative are lost in authority yet incident. The judge item within the body of lawful legal authority are to deal where the parties are subject matter and render a decision in his power and such in a sort of issue of the law. Accordingly, this proposed that the petitioner failed to establish a trial of a senior individual procedure by rule different from those required by law or otherwise committed authority the issue of the death of the said issue or the issue way la. Wherefore you are forward the revenue authorization issue is quiet and the authority is hereby denied. The claim of this court is hereby ordered to send money to the court below for money the draft days of no tradition and give effect is hereby so
In this case, was called for your local councillors M. Wilkins Frank, Arthur P. John A. James, and Fulman and Moji Tanaka appear for petitioners. Councillor Agnostic C. Fire, Solicitor General of Liberia, Richard J. Scott, Captain Tungu of the County, Chair E. Karawo, and G. Adolfo D. Command, the Ministry of Justice appear for respondent. Having reviewed the records and the arguments and contentions advanced by the councils representing the parties and consider the relevant law applicable thereto is here by a judge. That in this jurisdiction there is a distinction between a petition for the prohibition and that of the writ of certiorari. That the office of the former is to prevent and restrain imperial courts and tribunals which have no jurisdiction or have exceeded their jurisdiction and are proceeding irregularly in contrary to law. Whereas the latter is intended to correct an interlocutory ruling of a judge who does have jurisdiction but is proceeding irregularly and illegally. And in the incident case, assuming that the trial judge's ruling is binding in jury and awarding a new trial was erroneous, the trial judge certainly have personal and subject matter jurisdiction, and therefore, said ruling being interlocutory, the proper remedy should have been petition for a written certiorari to review and correct the ruling and not a petition for prohibition. Hence, it is not being the case, prohibition would lie. Wherefore, in the foregoing, the alternative rate issue is hereby patched, the preemptory rate denied. Type of this code is hereby ordered to send a mandate to the court below to resume jurisdiction in effect of this judgment. It is hereby so ordered. Giving on our hands the seal of the Supreme Court of the Republic of Liberia, it is 28th day of August 2026. Signed, Yami Koko, Senior Chief Justice, Supreme Court of Liberia. Chief Senator Howard Woodcock, Associate Justice, Supreme Court of Liberia. Joseph D. Naba, Associate Justice, Supreme Court of Liberia. Senator D. Clayton Johnson, Associate Justice, Supreme Court of Liberia. Baga N. Cannon, Associate Justice, Supreme Court of Liberia.
Yeah. Justice Khan is acting really agreeing, but acting they won't accept.
Except for what? Except for what? No, what did you? No, I didn't let I said standing on it. Except, no, you're not. No, you're not. Thank you, Anna.
President of the Republic of Liberia. The Speaker of the House of Representatives and the President of the Secretary, the Parliament that is for that but the man is sitting on God. Oh, right? After the year, when I was imposed, to my destination, when I came to the sea, he said, you have a certain the next one is manager of the criminal council. Thank you for the receipt of the life. Proceed or
Thank you. Let's pray. Lord, we thank you for having led this court with a large turn 2026. Thank you for your access. Thank you for guidance. Thank you, God, for your protection. As we all know, God, we ask that you would walk us and that you would keep us. The Lord has been you. The Lord is shine upon you and gracious Son. The Lord is confident upon you and give you peace. In the name of God the Father, God the Son, and God the Holy Spirit. Thank you, Lord.